approximately 1 or 2 weeks. I'm only trying. I've taken consent from the other side. They are not ready for today, but Monday, Tuesday they have sent.
What additional question are you seeking to bring?
Fine.
What additional question are you seeking?
It is related to Easement Act again.
Oh,
This is an admitted appeal, Easement Act. I was the person who has the property and the other side is claiming right of easement through my passage and staircase. So
and you
this
say
is
that easement act is not applicable.
not applicable, and as your lordship, then how it has to be
This
decided?
issue has not been decided so far. Easement act is it's quite an old act.
No, in this case, the appellate court takes into account this fact also, that Easement Act is not applicable, but old English law, good conscience and all those would be applicable, but does not discuss. So, your lordship, there has to be a judgment where a guideline has to be there as to how the matters relating to this has to be dealt. Otherwise, absolutely, the courts say that Easement Act is not applicable and then go on to decide the same in terms of the provisions of Easement Act. How that would be?
Ideally, it has to be taken up at the time of hearing. Because the issue
So-
of substantial question of law, we have to see the records
Yes,
and then frame a mind that
Yes,
yes, it is to be.
absolutely.
Have they responded to this interlocutory application?
we have filed
Do they
it.
choose to, you come, like for today they have not given consent, it's okay. But I would call upon them to file a response to that, if they choose to,
Yes.
right? That opportunity
So,
has to be there.
so at least your lordship may keep it on Monday, Tuesday, whatever.
He is not here, Mr. Arjun Kumar Chaudhary is not here. See, serial number 49.
Yes, I'm representing
What
Mr. Arvind Kumar Chaudhary.
Okay.
So other side is Birendra Kumar and
See, they might not be ready for the interlocutory application, but I can just pass an order
yes,
that if they want to file a response,
Yes,
they may
yes,
respond
yes.
and then fix it.
yes, I'll
So you just call upon them.
Yes.
Just a formal order to that effect.
absolutely.
You can come at 2:15 or
Yes,
2:30
yes.
and then that formal order. Because
Yes.
for all interlocutory application, normally
Yes,
an opportunity is required to be given.
absolutely. I'll not say that.
That's right. You will run my 2:15.
From supplementary list for to be mentioned case item 3 CIP 209 of 2024. Fine.
CLP का नंबर क्या है? फर्स्ट अपनी का नंबर
Three हो गया.
बस CLP number 209 of 2024. This matter has been listed at the instance of the office. It has been pointed out that in paragraph 5, the first appeal which has been restored, the number has been mentioned as FA number 223 of 2023 instead of FA number 222. Sorry. First appeal has been mentioned as FA number 2223 of 2023 instead of first appeal number 222 of 2023. Peruse the records. Considering the aforesaid facts, the order dated 29th August 2025 is hereby modified, and in the first line of paragraph 5, FA number 223 of 2023 is directed to be read as FA number 222 of 2023. Office to carry out the necessary correction in the order dated 29th August 2025. इनका कोई टाइम एक्सपायर कर रहा है कुछ ऐसा है 26/9 तक का टाइम काफी टाइम
From supplementary list for financial item 1, second appeal 129 of 1992.
This appeal is purported by defendant appellant.
नहीं करना है, so we'll see that.
Okay.
हाँ बताइए सर। आज एक मैटर डिक्टेशन के लिए था. I have not gone through the file fully, so I just post it on another date very shortly. एक दिन में ही, ठीक है?
I was of the opinion that the lordship will go through the judgment of second appeal, which will also hard on.
नहीं, आप इसको बहस करिए. कुछ काम पेंडिंग रहता है, तो उसी में थोड़ा बिजी.
नहीं, कोई दिक्कत नहीं है, लेकिन हमको आना ही पड़ता है.
You can just argue your entire case.
Appeal by defendants responded. Suit dismissed. Appeal preferred by plaintiff was allowed. Plaintiff has
So concurrent finding,
judgment of reversal.
a judgment of reverse.
Yes.
Suit was allowed.
Suit dismissed. And
Suit dismissed.
Yes. Appeal preferred by plaintiff was allowed.
Okay.
The plaintiff has filed a suit for the following relief. It be adjudicated that since Nanku died in the state of jointness with his son, Degar, who succeeded him by right of survivorship in the year 1952, and performer defendant number 6 and Lakshya Devi, and after her death, performer defendant number 7 had no right title interest over the land possessed jointly by Nanku and Degar, and therefore the sale deed dated 5/5/1977 executed by performer defendant number 6 and 7 in favor of defendant number 1 to 5 is sham illegal void ab initio, a paper transaction without consideration, and is null and void, are not binding on the plaintiff. By amendment, this was not incorporated in the decree of the trial court. And by amendment, a further relief was added that it be further declared that the plaintiffs are owners of 1/3 share of the land owned and held by Heman in Khata number 17 of village Balhara. And thereafter cost and other relief.
It is related to the same property.
Yes. This relief, which has been brought in on the record by amendment, has not been incorporated in the decree. I have not tried to.
But in the plaint I have seen it has been incorporated.
Pardon?
In the plaint I have seen it has been incorporated.
Yes. In the plate also, it has not been incorporated.
No, it has been incorporated. We have seen it only last year.
Oh, I need to be certified for it.
What is the date of amendment?
Just a minute. 2/8/1989.
Yes.
I have got certified copy. No, sorry, 18/4/1979. I have got certified copy of plate. In this also, that amended relief has not been incorporated.
18/4/79, right?
18/4/79.
It has been incorporated.
Oh,
Backside में है.
in certified copy it has been.
वो नहीं आया है.
Anyway.
In page number 10, it has been mentioned amendment by order number 22 dated 18/4/79.
Yes.
And it has been incorporated on the backside that it be further declared that the plaintiffs are the owners of 1/3 share of the lands owned and held by the Cayman in Khata number 17 of village
Yes.
Balatara.
Balhara.
This is amended by order dated 17/12/85. कहीं 17/12/85 लिखा हुआ है? कहीं सूट कब का है?
18.4 लिखा हुआ है यहाँ पर amended wide order number 22 dated 18.4.
18/4/79, लेकिन उसके पीछे भी शायद कुछ ऑर्डर हुआ होगा, 15 दिन में नहीं इंकॉर्पोरेट किए होंगे, तो इसलिए it has been incorporated. It is there in the plate.
Now let the
विनीत जी,
fact of the
इसका
case
प्लेट
is
का ध्यान रखना है, प्रेयर हम लोग को प्लेन से लेना है, और प्लेन का जो लास्ट पेज नंबर 10 है, उसके पीछे एक प्रेयर इंकॉर्पोरेटेड है. Yes.
well, the fact of the case is lengthy, and therefore we have tried to make out a genealogy. It is उनके बहुत से बेटे थे. It is in 2 pages.
2 pages.
Yes.
बलदेव महतो.
Hmm.
The common ancestor जिसका नाम यहाँ पे लिखा
Common ancestor बलदेव महतो.
बलदेव महतो, लेकिन इसमें तो डाइड इन जॉइनर्स में ननकू का नाम है.
मतलब the case is of Nanku's death. Nanku Mahto, first son of Baldev.
Yes. The rest we are not concerned. Are we concerned?
Then we are concerned with Nanku's property.
Yes, only Nanku's
Or
property.
Nanku's property.
Common ancestor is Baldev Mahto.
No
He
difference.
had 4 sons.
The fact is that Baldev Mahto, along with his 4 sons, had some land in village Balara. Some Darayas were inducted on some piece and parcel of land. Baldev Mahto had given some land in Rehan to Miran Mia and Kripali Mahto and his co-sharers, who were one of the Darayas long before service.
What is Rehan?
Mortgage. Soon after death of Baldev Mahto, his 4 sons separated in all respects. This is the case made out by the plaintiff. Some plots which were in possession of the Rayas were kept joint.
From where are you reading?
This is my notes. This is
ट्रायल जजमेंट्स.
ठीक है प्लेन से बता.
यहाँ से पढ़ सकते, प्लेन से पढ़ सकते, ट्रायल कोर्ट के जजमेंट में भी तो नॉर्मली सही लिखा है, एरर तो नहीं होगा
उसमें कोई एरर नहीं. तो हम शॉर्ट में नोट बनाए हुए हैं. The story is very long. अगर कहा जाएगा तुमने बस कॉपी है.
किसका? अच्छा, इसकी कॉपी.
हाँ, कॉपी.
नहीं सर, आप प्लेन से पढ़िए, अदरवाइज इट विल बी डिफिकल्ट. या इम्प्यून जजमेंट से पढ़िए. इम्प्यून जजमेंट में अमेंडमेंट वाला पोर्शन भी इनकॉर्पोरेटेड है.
वही तो नहीं मिला. Therefore, when I submitted that it has not been incorporated in the plane. I have got
ये
certified.
जो 1/3 वाला शेयर जो इंक्लूड हुआ है, उसके अलावा कोई
Yeah. In the first page bullet, after giving relief, the case begins from last line, para 2, the case of the plaintiff.
Sir,
Right.
I think that amendment has not been incorporated
Not
in the judgment. So आपको तो plain से ही पढ़ना पड़ेगा, amended plain से पढ़ना. Otherwise it is difficult.
Amended plate तो हमारे पास है नहीं, हम certified copy पढ़ा है. Since the trial court judgment in a very wretched condition, तो देखा जाएगा तो पहले थिन पेपर में होता था टाइप.
ये जो पार्टी ऐड हुए हैं वो सर आपके पास है प्लेन में सर्टिफाइड कॉपी दिखाई जरा सर्टिफाइड कॉपी.
आपके पास है
ना
कैंडिडेट
हम तो रिकॉर्ड देखने के लिए इंस्ट्रक्शन फाइल किए थे।
टाइम मांगने के अलावा कुछ और कर सकते हैं? टाइम के अलावा कुछ हो सकता है? सर आप ऐसा करिए कि ये जो प्लेंट है ना, जस्ट हैव अ लुक एट इट। ये इसी को पढ़िए,
ठीक
आई एम गिविंग इट। आप लोग दोनों जने मिलकर पढ़िए।
देखो ठीक से उठाओ,
और हम इसमें से थोड़ा देखें।
इसलिए बोले ठीक से उठाओ, नहीं तो आधा रह जाएगा नहीं।
रेस्पोंडेंट कहाँ है? दूसरे कोर्ट में चले गए ना? कहाँ है? आप हैं? ठीक है, आप साथ में पढ़िए। आप ही को बहस करना है, किसी और को बहस करना है? हाँ? कहाँ है? बस ये ना आना जाना नहीं चलेगा सब। ठीक है, जिसको रहना है उसको रहना है, नहीं रहना है तो जा सकते। आना जाना नहीं चलेगा। फिर दूसरा कोर्ट भी साथ में कर रहे, नहीं चलेगा। प्लीज डोंट डू दिस। तो अभी तक क्या कर रहे थे? फाइल भी नहीं है आपके पास। साथ में पढ़िए। हम इस चीज के लिए आई जस्ट डोंट लाइक इट।
May I take help of my friend?
हाँ, yes, yes, please read it.
I'll start from the first paragraph. Yes, the one Baldev Mehto of village Balhara had 4 sons, Rantu Mehto, Bhairo Mehto, Keher Mehto and Keman Mehto. Baldev Mehto had a regular Jamni village Balhara, over which he was in possession jointly with his sons, above named as member of joint Hindu undivided family. That the Baldev Mehto had inducted Uddu Miya, Miran Miya and Dayal Mehto, Kemchand Mehto and Kripali Mehto as their rayat over one or more pieces of parcel of land by 4 Kripali. Kripali Mahan had held as their rayat a large area of land.
By far, Kripali Mehto held as the rayat has a larger area. आगे पढ़िए।
That Baldev Mehto had also given in Rehan a large area of land to Miran Miya and Kripali Mehto as his co-sharers. That the Baldev Mehto died long before survey, leaving behind his 4 sons who succeeded him and came in possession of the land aforesaid and also came on collecting rent from the Rayats. That soon after the death of the Baldev Mehto, his 4 sons, Nantu, Bhairo, Keher and Keman, disrupted their joint family, separated in mess and residence and worship, and partitioned their land, expecting a few plots which were kept joint, and those land which were in hands of their rayat came in separate possession of their lands, which fell in their respective taktas, and also came on collecting rent before their rayats and dividing the same according to their shares. That thereafter came the last survey and settlement operations in village, and the rayati jamma of the sons of Baldev Mehto was recorded under Khata 17 of village Balhara in the name of Nantu Mehto, Bhairo Mehto, Keher Mehto and Keman Mehto, in defined equal shares and their separate taktas of land in khas and exclusive possession of each recorded in their respective kabzari in remark of column. In the land in hands of the rayats were shown in Shamilat. Those lands which have been divided among the 4 brothers at the right of partition were also shown as Shamilat. The 4 sons of Baldev Mehto thus came in khas and exclusive possession of their respective lands without any claim or interruption from one or the other.
So their claim is that there was some partial partition at
Yes.
previous point
Yes,
of time,
partial partition.
And so far as the area regarding that year, and there were certain properties.
Partial
which remained
partition and regarding the most important thing, date of death of Nanku.
Okay, we'll see that.
Therefore, whether his other daughters or daughter's son will inherit or not, because they have executed this deed.
Okay.
Okay.
Yes, please carry on. 7.
That of the Dar Raya, Miran Mia died immediately after survey issueless, and his Dar Rayati plots came in exclusive possession of the sons of Baldev Mati. These plots are 694 and 696. Miran held plot number 65 and 686 in mortgage, which mortgage money were paid to him after survey by the four brothers Nanku, Bhairo, Keher and Kheman, and these brothers came in class possession of these plots as well. Similarly, Dayal Mahato also died after the survey and his family became extinct. Therefore, his Darayati plots were also brought in class possession of Nanku and his brothers. Darayat Kripali Mahato's descendants surrendered plot number 801, 808, 782, 706 and 762 in 1970 to the plaintiffs, defendants and
Just pause it for a moment, sir. How does this Darayati plot comes to khas possession of Nanku?
Because
It
they-
should come to
they-
the joint possession.
Yes, the righty plots were recorded in joint possession.
Yes, therefore it should be Nanku and others.
Yes.
Correct?
class possession of Nanku and his brothers.
But all the three
Ah,
brothers.
that's, I missed it. Chali, carry on.
Darayati Kripali Mahato's descendants surrendered plot number so and so to the plaintiff's defendant and the heirs of Bhairo, and these persons are in possession by dividing the same. That soon after the surveys, Nanku, Kheman and sons of Bhairo and Keha in or about the year 1928 divided the Shamilat plots which were in their khas cultivating possession for the sake of convenience without any partition by meets and bounds in 4 shares and came in separate possession of their respective lands. The separate lands in possession of Nanku Matu in the Shamilat plots for the sake of convenience are described in Schedule E of the play, and the Kabjawari plots of Nanku Matu, which he got by partition before survey, are described in Schedule A of the play. That Nanku Mahto on 5/7/26 obtained Rayati settlement of 3 bighas 7 kathas of Gair Mazarwa land, which he had already reclaimed with the permission of the then landlord Tikait Birendra Narayan Singh of Doranda Estate in occupancy right by virtue of registered patta of the date and continued in possession exclusively. Then again Nanku Mahto obtained Rayati settlement of 1.38 acres from the self same Tikait Birendra Narayan Singh, which he had already reclaimed into Dhan Khet by an registered patta dated 7/9/43 and continued in possession. These lands appertain to Gair Mazarwa Khata number 1 of village Karmatan and are described in Schedule C of the play. That Nanku Mahto had 2 sons, Rupan Mahto and Degan Mahto, and father and sons were members of joint Hindu undivided family. Rupan Mahto and his wife, however, predeceased Nanku Mahto in state of jointness, having died in quick succession in or about in the year 1928, leaving only 2 daughters, Jashoda and Tekni, pro forma defendant number 8 and 9. Thus, after the death of Rupan Mahto, his father Nanku and his brothers Degan Mahto continued as members of a joint Hindu undivided family and remained in possession of Schedule A to C lands of the plate by the rule of survivorship. Then thereafter, Nanku Mahto died in the state of jointness with his son Degan in the year 1952, leaving his only son Degan Mahto and 2 daughters, Vedni and Lakhya, and therefore, on Nanku's death, Degan Mahto succeeded by right of survivorship as sole surviving co-partner and came in exclusive possession of Schedule A to C lands of the plain. Vedni is pro forma defendant number 6 and Lakhya died as a widow, leaving behind her only son Harku Mahto, pro forma defendant number 7. Thereafter, Degan...
This 6 and 7 have sold the property in favor of defendant number 1.
Thereafter, Degan alone came on paying rent for Schedule B lands and came on obtaining rent receipts. Degan also came on contributing his share in the lands of Khata number 17 after the vesting of Zamindari rent for Khata number 17 used to be paid jointly by the contribution of all owners of Khata 17, but sometime after the Karamchari and the Panchayat Sevaks have made a mess of everything and has been accepting proportionate rent from one or the other owners and has been issuing rent receipts without any sense of proportion. But nonetheless, the owners are paying rent according to their respective shares. The Bhairav Mahto had left behind two sons, Shiv Mahto and Lethal Mahto. Shiv Mahto had also left behind two sons, Heman and Mohan. This Heman is defendant number 5. Similarly, Keher left behind 4 sons, named Bandhan, Tipan and Pain, who are defendant number 1 to 4. Tipan has 3 sons, Tejo, Tilak and Churo. On the report,
ये 13 है, kindly turn it, I'll write it for you.
नहीं पीछे में है
आपके में नहीं है ना?
नहीं हमने
हम लिख दे रहे हैं।
हाँ,
ऐसे पेंसिल से
amendment
लिखा
आया
है।
है पीछे
बताइए क्या लिखा है?
that Heman died issueless and a widow in the year 19...
Heman died issueless and
a widower in the year 1931.
1931.
And his interest in the lands of Khata number 17
Khata number 17.
of village Balhara,
Spelling
Balhara,
Malhara.
was succeeded by his brothers Nanku, Keher and Bhairo. And they came in possession accordingly.
That's it.
By dividing the lands of Khema.
On the basis of this fact, relief was amended.
That's
Double
it. That's it.
That Degan Mahto, however, died in the year 1954, leaving behind his widow, Musmat Tipni, plaintiff number 5, and 4 daughters only, namely Hulia, Savitri, Devli, and Kaidi. Therefore, on the death of Degan Mahto, Musmat Tipni succeeded to the entire interest left behind by Degan Mahto in the lands of Schedule A to C and came in exclusive possession of the Schedule A to C lands of the plain. So far as the lands described in Schedule B is concerned, Musmat Tipni came on paying rent exclusively, and for the lands of Khata number 17, she came on contributing her share of the rent. Subsequently, rent has also been realized from her without any sense of proportion for Khata number 17, and she and other owners are being issued separate rent receipts. That after some years, after the death of Degan, that is in or about in the year 1968-69, the defendants started trouble and began to move to lure the daughters of Rupan Mahto, namely pro forma defendant number 8 and 9, to foster litigation by executing some sham sale deeds in their favor. Pro forma defendants and the plaintiffs, seeing this sinister move of the defendants, pro forma defendants proposed to the plaintiffs to obtain a most formal deed of sale in respect of Rupan's supposed undivided interest in the lands described in Schedule A to C of the plain, so as to silence the defendants and the whole world. The plaintiffs, also viewing the situation, and thought pro forma, and though pro forma defendant number 8 and 9 had no interest whatsoever in Schedule A to C lands of the plain, agreed to obtain a formal deed of sale from pro forma defendant number 8 and 9, and accordingly, pro forma defendant 8 and 9 executed 2 formal registered deed of sale in respect of Rupan's supposed undivided share on 17/6/69, both in favor of plaintiff number 1 to 3. The defendants were thereafter silenced as their game and aim was frustrated. That finding the dishonest intention of the defendants, plaintiff number 5.
Just a moment. This defendant number 8 and 9, they executed the sale deeds in
in
favor
favor
of the
of
plaintiffs.
in favor of plaintiff.
So plaintiffs is not
Yeah.
agreed by that.
No, he has not challenged those sale deeds.
Okay.
He has challenged the sale deed executed by defendant number 6 and 7 in favor of defendant number 1.
Okay. The same property, with respect to the same property.
Pardon?
With respect to the same property.
With respect to land of Khata number 17.
But this deed of 17669, the area and the boundary is the same as that of the other deed.
It has not been matched either by either of the courts.
And there is no finding to that effect.
Not matched.
What is the
Now
total area of Khata number 17?
This has also not.
This is also not.
Now let
Yes, please continue.
yes. 16.
2016.
That finding the dishonest intention of the defendants, plaintiff number 5, sonless as she was, and had kept plaintiff number 6, husband of the plaintiff number 3, as her jamai, thought it neat and proper to transfer half of the lands described in Schedule A to C of the plaint in the name of her daughters and son-in-law, plaintiff number 1 and 4, to retain half for herself till her lifetime. Therefore, she, plaintiff number 5, executed a sale deed in respect of some lands of Khata number 70 and Khata number 1/2 and 1/23 in favor of plaintiffs numbers 3 and 6 on 28/5/69 and put them in possession. Subsequently, on 9/8/69, plaintiff number 5 executed another sale deed in respect of some lands out of Schedule A to C lands in favor of plaintiff number 2 and 4 and put them in possession, retaining some lands for herself. Thus, the plaintiffs have joint title to the lands of Schedule A to C described in the plaint and have been in peaceful, uninterrupted, and continuous possession of them to the knowledge of the defendants and the pro forma defendants and the whole world. That having lost their initial gain, the defendants threw their net on pro forma defendant number 6 and 7 and succeeded in winning over them. Thus, when the defendants succeeded in bringing pro forma defendant numbers 6 and 7 to the clutch by falsely luring them for some monetary gain, the defendants promising them some advantage either by way of money or land, they brought them to Jammu and for want of stamps available outside with the stamp vendors for the value of ₹6,000, they got 2 sale deeds executed by pro forma defendant number 6 and 7 in their favor on 5/5/77. Purporting
This very deed was challenged.
to be in respect of 8 annas share in the lands described in Schedule A to C land, belonging at one time to Nanpu and thereafter to Devan, his only son, without any right or authority. The said sale deeds executed by pro forma defendants in favor of defendant number 1 to 5, dated 5/5/77, are sham paper transactions, illegal, void ab initio, without consideration, null and void, which have not created any title in favor of the defendant number 1 to 5, nor have pro forma defendant number 6 and 7 any title which could be extinguished. These sale deeds have simply afforded a handle to the defendant number 1 to 5 to whip a false litigation and harass the plaintiffs. The plaintiffs are, however, in undisturbed, peaceful, and continuous possession of the lands described in Schedule A to C of the plaint. But because of the bringing into existence the false sale deeds, the plaintiffs have been advised to seek a declaration that those sale deeds dated 5/5/77 are not binding upon the plaintiffs, nor have they affected in any manner the right, title, and interest of the plaintiffs over the lands covered by the influent sale deed. The sale deed dated 5/5/77 is left outstanding. If left outstanding, may injure the title of the plaintiffs, hence the necessity of this
That's right,
suit.
got it. What was the case of the
The
defendant?
important thing is that they have filed suit for declaration. They have paid the court fee, a fixed court fee at that point of time, ₹29.75. And therefore we have challenged in our written statement that proper court fee has not been filed. It is not a simple suit for partition or declaration.
It is seeking a,
It is,
it is in connection with title also.
yes, it is suit having consequential rate. Therefore, they would have paid the entire value, court fee on the entire value of this LD.
So there are two distinct prayers altogether.
Yes.
One is for partition, and the other is for declaration that the sale deed is void.
Why? Therefore, we have challenged in the written statement that a fixed ad valorem court fee of the value of the sale deed ought to have been paid.
Let us see the issues.
This has been taken note by trial court.
Yes, let us see the issues framed by the trial court.
Yes, but trial court.
Internal page 21.
नहीं उससे नहीं इसका
ये इनको वापस कर देंगे और हमारा रिकॉर्ड हमको वापस कर देंगे। जो अमेंडमेंट था वो मैंने डाल दिया।
एक अमेंडमेंट केवल हुआ
हाँ।
प्लीडिंग
और बाकी तो दूसरा आपको पता ही है।
हाँ डबल ए वाला।
अब मैचिंग हो गया ना?
हम लोग के पास जजमेंट हो पढ़ने लायक है ये नहीं।
इसीलिए तो हमको सर्टिफाइड मंगाना पड़ा, उसके बावजूद भी मिस्टेक रह गया। डबल ए इनकॉर्पोरेटेड नहीं है, 12A वाला अमेंडमेंट का इनकॉर्पोरेटेड नहीं है।
अब बताइए इश्यूज।
Issues internal page 21.
यस आई।
Para 28. On the basis of the pleadings and start of arguments, following issues were recasted.
रोमन 5। अभी हम लोग फॉर एक सब्सटेंशियल क्वेश्चन ऑफ लॉ पर देखते हैं ऑन द पॉइंट ऑफ कोर्ट फीस, राइट? रोमन 5, करेक्ट?
Are the plaintiffs entitled to get any relief on or release without paying the ad valorem court fee?
Let us see what is the finding. आपको कोर्ट फीस भी सुनेंगे सबसे पहले, आप तैयार होंगे। Let us see what is the finding.
Page 20.
Running page 77, internal 27, para 30, 38.
27. Yes,
Para 38.
para 38.
According to the defendants, the plaintiff really have designed to get a declaration of title with respect of A to C lands as exclusive owners, and the plaintiff speaks that the plaintiffs also want to get declaration with the Shamilar lands of Khata number 17, admin partition, and the Schedule B lands were allotted in the share of Nanku Mehta. And at the same time, the plaintiffs also want to get a declaration that the sale deed stated 5577 be declared as null and void. And they also want to get a declaration that the defendant number 1 to 5 have no title over Schedule A to C lands, only by paying a fixed court fee, that is rupees 29.25 as declaratory suit. So actually the plaintiffs want to get so many reliefs in the regard of this declaratory suit without paying the ad valorem court fee and without paying the separate court fee against the separate release. And the suit is not maintainable at all and fit to be dismissed. On perusal of record, it appears that this is not a simple suit for declaration of the sale deed 5577 to be illegal, void ab initio, paper transaction without consideration, and is null and void, and are not binding to the plaintiffs. But at the same time, it is a suit for declaration of title over Schedule A to C lands, and for this, the suit has not been properly valued. Even the plaintiffs have not paid ad valorem court fee on the consideration amount of rupees 6,000 of the sale deeds dated 5777. Under above circumstances, in view of non-fixation of proper court fee on the plaintiff suit is not maintainable. As such, issue number 5 is decided against the plaintiff.
Now let them,
by the trial court.
the finding of the appellate court में कर ली मिस्त्री ने। ये पॉइंट है। हाँ ये पॉइंट है। Beloved, issues have been.
रुक जाइए, हट गया।
नहीं नहीं।
Just
ओह
अभी रिकॉर्ड पढ़ा हुआ।
ये कहाँ का?
अपलोड का फाइंडिंग पैराग्राफ 30 में है
देखो।
कोर्ट फीस पर।
पढ़िए पैरा नंबर 30 बोल रहे हैं।
जी 30 में
पॉइंट नंबर 2
पॉइंट नंबर 2
पढ़िए जरा।
गलत है वो अभी
बढ़िया
32
इंटरनल पेज नहीं इसमें थोड़ा मेरा पढ़ने वाला है
मिल गया।
मिल
Learned advocate on behalf of the respondents argued before me that the suit has been filed in garb of title suit and for confirmation of possession, and so the plaintiff appellant should pay the ad valorem forfeit, and accordingly, it is not a case of declaratory only. On the other hand, the learned advocate for the appellant submitted that there is no consequential relief sought for, and it is purely a declaratory suit for declaring the sale dated 5/7/77 as sham, illegal, without consideration, and null and void, and 1/3 share of the land owned and held by Cayman Matter. The learned advocate on behalf of the appellants also relied upon cases reported in so and so, so and so. It is well settled that the suit can be brought by the plaintiffs according to her own suitability, and in the instant suit, apparently there is no consequential relief sought for by the plaintiffs. Under the above facts and circumstances of the case, I find that the plaintiffs have played the court fee properly. Hence, this point is answered.
Now we have
What
given
is
two.
the error in this?
We have given two judgments. One of Patna High Court and another of probably Supreme Court. नहीं है नोट करा
Fine, no. One is Patna High Court 77.
Yes.
77 Patna 59. Correct?
One is 1956 Patna 203. नहीं 77 पटना अगर है तो वो तो जॉइंट फैमिली प्रॉपर्टी लेके होगा एंड 2010 वॉल्यूम 12 SCC पेज 112
एक सेकंड पहले 1956 पटना देखते हैं। नाइनटीन 56 पटना नहीं दी है।
नहीं
मंगाइए सर 1956 पटना पेज नंबर
203 देखो
गोराई जी को बोलिए पेज देंगे।
नहीं
आप कौन सा सुप्रीम कोर्ट का जजमेंट रिलाई कर रहे हैं? 2010-12 SCC
एक 2010 वॉल्यूम 12 सुप्रीम कोर्ट केसेस पेज 112 para 5 to 10 and 7. So one is 1956, 56 Patna, page 203.
56 पटना इंप्यून जजमेंट में रेफर्ड है तो पहले इसको देख लें। There is no alternative relief also of recovery of possession.
No.
Not specifically.
No.
There is no alternative relief of recovery of possession. They are simply seeking a declaration that is void.
For declaration that is
And they say
changing.
that they are already in possession of the property.
पोजीशन का तो नहीं है कोई रिलीफ अभी रिलीफ है कि ये सिंस नॉट
एक सेकंड आपको मौका मिलेगा तब बोलिएगा।
Now we
बीच
are,
बीच में मत बोलिए क्योंकि जब आपसे सवाल पूछेंगे तब आपके पास जवाब नहीं भी हो सकता है, इसलिए थोड़ा मनन करिए और फोकस करिए। चलिए
नहीं The main relief is for declaration of sale deed of 1977 and null and void.
And for
then-
partition.
Yes. And there is one judgment of our
सर
own
लगता है
High
कोर्ट
Court.
फीस तो सही डिसाइड कर
Pardon?
कोर्ट फीस तो लगता है सही डिसाइड कर
And
और कुछ अगर आपको डिफर करना है इससे तो बताइए
differ करना है, therefore we have
ये
submitted
दो
this.
जजमेंट्स आप रिलाइज
And there is one judgment of our own High Court reported in 2018 volume 2 JBCJ page 377.
ये तीनों में से कौन सा जजमेंट सबसे पुराना है उसको पहले पेश करें
सबसे पुराना 56
पहले कौन सा पैराग्राफ आप पेश
Yes.
करें
Yes. Para 6 and onward. नहीं, ये JBCJ का हम बता रहे हैं para 6 and
नहीं आप
onward.
पहले ये 56
56 पटना का अनफॉर्चुनेटली हमारे पास उसका कॉपी नहीं है. Probably it was submitted earlier before another. देख के बता.
पटना में तो ऑलरेडी दे दिया गया
56 नहीं इसको मंगाने पड़ेगा उन्होंने तो अपनी कॉपी दे दी
नहीं, वो हम देख के बता देते हैं रेडिमेड पैराग्राफ.
नहीं आपको साथ में पढ़ना होगा इसका क्या करना है प्रिंट करना
केवल दो ही पैरा छोटा सा स्टेटमेंट पैरा 3 एंड 4. कर लीजिए, कॉपी कर लीजिए. नहीं, copy. Yes.
आप इसमें आ जाइए सुप्रीम कोर्ट का डायरेक्ट जजमेंट है जो आपने साइट किया 2010-12 SSC 1/9. It's a direct judgment. All the three circumstances have been taken care of. And in this case, he is seeking confirmation of possession. He is not the executant of the deed.
No, he is
He is
not.
not the executant of the deed. Third party has executed the deed, and he wants a simple declaration that this deed is null and void. That's it. So therefore, fixed court fees has right to be paid. Ad valorem court fees नहीं लगेगा. और कुछ बोलना है तो बताइए.
नहीं, कोर्ट फीस में और कुछ नहीं बोलना है.
आपको बोलना है कुछ.
हमको आपको आप ये कह दिए
नहीं, ऐसा कह
आप
दिए।
कोर्ट पर बोली थी तो
आप
कोर्ट
बताइए आपको क्या बोलना है.
आप हमारा जो है सिंपल डिक्लेरेटरी सूट है और पैराग्राफ 29 ऑफ अपीलेट कोर्ट जजमेंट हमको रिफर करना है और पैराग्राफ 30 ऑफ अपीलेट कोर्ट जजमेंट
28.
29 एंड 30
29 is for what?
और
Court
इस
fees.
पर हमारा डीपीएस जस्ट
कोर्ट फीस कट नहीं है ना वो.
कोर्ट फीस वाला नहीं है कोर्ट फीस वाला 30 में है
अच्छा आप
पैराग्राफ
सुनिए इसका
बस इतना ही मिला
Substitution question of law
नहीं मिला
देखिए तो इसका प्लेन ऐसे नंबर 129 of 1992 लिख सकते हैं.
May I leave? Basic.
No, no.
ठीक हो
देखिए इस कोर्ट में आपको सेकेंड अपील फर्स्ट अपील बहस करना है तो बाकी सब जगह से फ्री होके आइए, नहीं तो मत आइए।
सॉरी
अगर आपका लिटिगेंट आपको देख लेगा ना ऐसे इधर उधर दौड़ते हुए और जब आप बोलते हैं कि हम तो पढ़ ही नहीं पा रहे हैं, तो आप सोचिए कि क्या उसके दिमाग में क्या गुजरेगा। थोड़ा सोचिए, और ये रिकॉर्डेड प्रोसीडिंग है ना, वो कभी भी देख सकता है। कल आप हार जाएंगे और वो देखेगा कि मेरा वकील साहब बीच बीच में छोड़ के चले जाते हैं, तो आपका क्या इमेज बनेगा।
सॉरी
नहीं सकते हैं ना तो मत करिए, डोंट डू इट। हमें माइके से अपॉइंट करके नहीं कर देंगे, आपको कोई दिक्कत नहीं, प्लीज डोंट डू दिस। इसका फर्स्ट पेज है, देखिए ऐसे नंबर 129 of 1992. This appeal was admitted for final hearing on the following substantial questions of law. The learned counsel for the appellant has first argued the substantial question of law number 2. He submits that the learned trial court held that ad valorem court fees was payable and consequently held that the suit was not maintainable on account of non-payment of ad valorem court fees. He submits that specific issue was framed by the learned trial court to that effect. So far as the learned first appellate court is concerned, this finding was reversed and it was held that fixed court fees was sufficient. The learned counsel submits that considering the nature of relief paid for, ad valorem court fees would be paid. And the finding of the learned first appellate court is not in accordance with law, and accordingly the same is fit to be set aside, and the substantial question of law be answered in favor of the appellant. The learned counsel has एक judgment बहुत है सर, और भी कुछ judgment है।
कोर्ट फीस पर ऊपर में लिखा हुआ सुप्रीम कोर्ट,
हाँ
दैट इज ऑन सुप्रीम कोर्ट फीस
हाँ,
5 to 10.
that should be sufficient. एक judgment.
एक जजमेंट कोर्ट का दिया है.
The learned counsel for the appellant has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2010, bracket close 12 SCC, paragraph page 112, and has submitted that different situations have been considered by the Honorable Supreme Court while considering the issue as to when the ad valorem court fees or fixed court fees will be payable. The learned counsel for the respondents has opposed the prayer and has submitted that no consequential relief was prayed for, and therefore there was no question of ad valorem court fees. He has submitted that the sale deed which was under challenge was by the challenge to this was not executed by the plaintiffs, and there was a specific relief to seeking a declaration that the sale deed was void. And he submits that the fixed court fees payable for declaration was required to be paid. The learned first appellate court has considered the matter properly, and therefore the substantial question of law number 2 is fit to be answered against the appellant and in favor of the defendants. After hearing the learned counsel for the parties, the prayer made in the suit is as follows. The perusal of the prayer reveals that the plaintiff did not seek even an alternative relief seeking possession of the property. The perusal of the plaint also reveals that the sale deed which they sought to be declared as null and void was not executed by any of the plaintiffs. The plaintiffs being in possession, they simply sought a declaration that the sale deed in connection with the property in their possession was null and void. Essentially, the suit was a declaratory suit. This court also finds that a further relief was introduced in the plaint seeking partition of the suit property and claiming 1/3 share. The records reveal that fixed court fees with respect to the claim of partition was also paid. In the judgment passed by the Honorable Supreme Court, which has been cited by the learned counsel for the appellant, different situations have been considered with respect to the relief seeking cancellation of said deed. Paragraph 7 of the aforesaid judgment is quoted as under. This court finds that, keeping in mind the aforesaid ratio and examples as provided by the Honorable Supreme Court in the matter of determination of court fees, this court is of the view that, in the light of the nature of relief sought for, the fixed court fees was payable. The finding of the learned first appellate court, holding that fixed court fees was payable, is in accordance with the judgment passed by the Honorable Supreme Court, reported in bracket 2010, bracket close 12 SCC 112. Accordingly, the second substantial question of law is answered against the appellant and in favor of the respondents. A first value. Let us see the first one.
Yes. The second was whether the suit being a suit for declaration of title upon adjudication of number two was with respect to court. Number one was whether in view of documentary evidence exhibit 1 series being several decisions showing transaction between the parties establishing the factum of previous partition and showing that such partition being acted upon, the claim of partition and for title is barred by principles of estoppel, waiver, and acquiescence, and is initiated under provisions of section 52 and 116 of Evidence Act.
Sir, इसके just a moment, इसके plain के पीछे लिखा है the suit is for partition and fixed court fees of such and such has been paid. It is there in the plain itself. ठीक है, तो partition का भी जो fixed court fees था वो भी paid.
Partition का fixed court भी होता है, but they have paid only one court fee, one fixed court fee.
लेकिन इस
not separate.
इस तरह का substantial question of law इस तरह का नहीं.
नहीं, substantial question of law
इस तरह का नहीं.
But the fact, while considering a court fee matter, your lordship can take it into consideration. That दो relief है इनका, दोनों declaration का और partition का, तो कम से कम दो court fee mix करना.
जब initially suit file किए होंगे, तब तो अपना declaration का suit court fees file किए ही होंगे ना?
एक तो 29-25 फाइल किए ही है.
और?
लेकिन दूसरे रिलीफ के लिए जब amend किए, इनको फिर partition का court fee देना चाहिए था.
नहीं तो पार्टीशन का तो कोर्ट फीस लिखा ही हुआ है ऐसे दिया हुआ.
और जहाँ
उस तरह का सब्सटेंशियल
रिलीफ नहीं I do repeat it.
ठीक है. फर्स्ट सब्सटेंशियल क्वेश्चन.
Well, in view of the pleadings of the party, other issues have been framed, and the important one was issue number 4 and 8. Issue number 4 was, is the suit effective for non-joinder of parties? And 8 was whether the scheduled B plot were partitioned among the sons of Baldev Mato as the plaintiff stated in their pleading in the year 1928. This has been taken note by trial court in para 34, internal page 24
We are concerned with issue number 4
and 8.
and issue number 8. Where is the finding?
Yes,
Page 24, Lordship. Internal page 24.
Yes.
Para 34.
Sarah. Yes, please. They are taken up together.
Yes, Lordship.
Okay.
Issue number 4 and 8. These issues are taken up together. Is the suit defective for non-joinder of parties? According to the contesting defendants, there is 3 schedules in the plate, which is Schedule A, B, and C. Schedule A land are exclusively the land shown in Parcha as the lands recorded in the name of Nanku Mato during cadastral survey settlement. According to the case of the plaintiffs, there was some land which was Shamilat or joint land of 4 sons of Baldev Mato. Those 4 sons of Baldev Mato were Nanku Mato, Bhairav Mato, Keher Mato, and Kheman Mato. The joint land, 4 brothers, were partitioned in the year 1928, and the share allotted to Nanku Mato has been placed in Schedule B of the plate. Schedule C is the self-acquired land of Nanku Mato. According to the defendants, the Shavilar lands of 4 brothers were never partitioned among them by meets and bounds, and which are joined by law, and the plaintiffs have not succeeded to show any partition by any documentary evidence. And when the sons of Keher Mato and grandsons of Bhairav Mato were made party, then why not the other descendants of the branch of Kheman Mato were made party? According to these defendants, the suit is defective for non-joinder of party, such as Shobha Mato, sons of late Mohan Mato, Dhanya Devi, wife of Hiraman Mato, Bhatani Devi, daughter of Kheman Mato, and wife of Sukar Mato, are necessary parties, who are the heirs of Kheman branch, Keher branch, and Bhairav branch. At the same time, it has been pleaded that the suit is barred by law of limitation. These facts, as mentioned above in para 5 of the written statement. On perusal of the record, it appears that according to the pleadings of the plaintiff, Nanku Mato had 2 sons, Rupan and Degan Mato. Rupan and his wife died before Nanku Mato in the state of jointness in quick succession in or about the year 1928, leaving behind 2 daughters, namely Jashoda Devi and Tekni Devi. Proforma defendant number 8 and 9. So, proforma defendant number 8 and 9 had no legal right, and according to them, after death of Rupan, his father Nanku and his brother Degan became the owner of Schedule A to C properties by rule of survivorship. At the same time, the plaint itself discloses in para 15 that the plaintiffs, viewing the situation, got sale deed registered for Schedule A to C lands in their favor from defendant number 8 to 9, who are daughters of Rupan Mato. Plaintiff number 1 to 3 got 2 sale deeds executed by defendant number 8 and 9 on 17/6/69 with respect to Rupan's supposed undivided share. Now, from the very pleading of the plaintiff, it becomes clear that the story of partition of Shavila land belonged among the 4 sons of Baldev Mato has been falsified by the above fact. So, there was no partition among the descendants of Baldev Mato in the year 1928. So far, the joint lands of 4 brothers of Nanku are concerned. In such circumstances, the descendants of all members of the branch of Bhairav, Kheman, and Keher are necessary parties, but in spite of the above assertions of the defendants in para 5 of the written statement, the plaintiff took no trouble to amend the plaint and make them necessary parties. Under the above circumstances, the suit is defective for non-joinder of necessary parties. As such, issue numbers 4 and 8 are decided against the plaintiff.
So this is with respect to non-joinder of necessary party when it comes to partition. With
yes,
respect to partition.
yes,
Right? And what is the finding of the learning first?
yes, appellate court. It is point number 1. Point has been given in para 8.
Yes. Para 29 is the finding.
Yes.
Point number 1. The defendants claim that the suit is defective for non-joinder of parties because Heron's branch, and Keher's branch, who are necessary parties, have not been made parties in this case. But from perusal of the plaint, it appears that branch of Keher have already been made parties in the suit. It is admitted position that the branch of Nanku Mato has also been made party in this suit, who are actually the necessary parties in the suit. It is claimed by the plaintiffs that Heman Mato died issueless, so there is no question of making parties from his branch. The learned advocate appearing on behalf of the appellants argued before me that the lower court has committed error in holding that the suit is defective for non-joinder of necessary parties, but from record it appears itself that the heirs of Nanku Mato and Keher Mato, as well as others, have duly been made parties in this suit by amendment also. It was argued by the learned advocate for respondents that Mosumar Deoli died on 16/2/82 and the appeal has not been filed on her behalf. But from the record it appears that petition was filed to expunge her name and substituted her legal heirs, which was allowed by the appellate court on 8/7/82. So there appears no lacuna. There is specific case of plaintiff responded that Heman Mato died in the year 1931 issueless, being a widower. Considering the above facts and circumstances in this case, I find there is no defect for want of necessary parties in this suit. Moreover, the appellant has only sought for relief of 1/3 share in the properties of Heman Mato.
This is the point. Now let admittedly the land
Let
which
us
has
come to
been
the question of law once again.
Yes. Not a specific point, substantial
आप जो
question.
बोल रहे हैं उससे कोई कोरिलेशन ही नहीं.
ठीक है,
प्रीवियस पार्टीशन का फाइंडिंग है.
प्रीवियस पार्टीशन का फाइंडिंग है. प्रीवियस पार्टीशन का फाइंडिंग अगर है तो कब्जावारी जो लैंड रिकॉर्डेड था, इट हैज आल्सो बीन एडमिटेड सम लैंड हैज बीन.
नहीं, पहले सब्सटेंशियल क्वेश्चन ऑफ लॉ पढ़िए, उसके बिना तो हम लोग ऐसे तो नहीं बहस कर पाएंगे.
नहीं, उसमें यह
नॉन जॉइंडर ऑफ नेसेसरी पार्टी
पहला, हाँ एक ही है पहला. नॉन जॉइंडर पर कोई
नहीं है. आप इसको जरा पढ़िए.
कोई क्वेश्चन.
वेदर इन व्यू ऑफ द डॉक्यूमेंट्री एविडेंस exhibit 1
Whether in view of the documentary evidence, exhibit 1 series, being several decisions showing transaction between the parties establishing the factum of previous partition and showing that such partition being acted upon, the claim of partition and for title is barred by principle of.
सर एक बात बताइए, पार्टीशन का division by mix and match.
By mix.
Both the elements are important.
Yes.
Right? Merely because one person is selling some property or different members of a joint family are selling some property, that by itself cannot be said to be an evidence of partition. So even if if there is a finding that there was a previous partition, then
Yeah.
that is different.
Yes.
We have to see whether there is a finding that there was a previous partition or not by the learned first appellate. वो तो जजमेंट है ना, मिक्स एंड बॉन्ड से होना चाहिए. Merely because somebody has sold some property that is of no use. I think किसी सेल डीड में लिखा हुआ है that there was a previous partition ऐसा करके, right? कहीं तो देखें.
Now let
एप्लेट कोर्ट का फाइंडिंग है जॉइंटनेस का नहीं. एप्लेट कोर्ट का फाइंडिंग अल्टीमेटली क्या है?
jointness का है.
जॉइंटनेस का फाइंडिंग
Yes.
है.
That
There
is
is a
point
finding of
number.
appellate court on the point of jointness. Point number 1 and point number 2. दो ही पॉइंट है.
One में आया था defective non-joinder.
तो नॉन जॉइंडर पर है.
हाँ, उसी को डील करने में आया था point number 1.
पॉइंट नंबर 1 में कहाँ जॉइंटनेस का कुछ नहीं?
ये
There is a finding that Nanku Mehto had died in the year 1951.
this is the important sense. His daughters and daughter's son have sold the property of 1977 then. And that was challenged by the plaintiff. Therefore, it is important whether they inherited or not.
ऐसा तो substantial question of law नहीं है ना सर?
This issue. While dealing with issue number 4 and 8, the trial court has specifically stated.
It becomes clear that the story of partition of Shamlat lands among the 4 sons of Baldev Mahto has been falsified by the other family.
Where is the finding? Para number?
Para 35, page 26.
Page 26 के 4 लाइन ऊपर से 4 लाइन, चौथा लाइन.
So there was no partition amongst the descendants of Baldev Mehto in the year 1928. So now there is a finding that there was no previous partition.
Previous partition.
Now merely by virtue of Exhibit 1 series, can it be construed that there was a partition? This is a substantial question.
Since the deed of the year 1977 recites as such that there was partition. That was before dispute between the parties.
Okay, let us see exhibit, whatever you are saying of the deed must be a part of Exhibit 1 series.
Yes.
Let us see 1 series, like Exhibit 2, 1 series.
देखो डेली है
You see, the claim is that
Pardon?
the trial court held that in the year 1928 also there was no partition.
As
Although
alleged
the
by
plaintiff had claimed that there was a previous partition and it was only partition was due in connection with some of the properties.
and will at the some property in their earlier record of right recorded as Samilak.
Yes.
Samilak. Samilak मतलब
joint.
पार्शियल पार्टीशन नहीं हो सकता है, हिंदू में भी नहीं हो सकता है. पार्शियल पार्टीशन हिंदू मुसलमान किसी में नहीं होता है. Therefore, it is wrong to say that partial partition was made in the year 1928 and subsequently हेमंत का राइट जो है हेमंत का 1/3 हमको दिया जाए. पार्शियल पार्टीशन इज प्रोविडेड दैट पार्शियल पार्टीशन
एग्जिबिट 1 सीरीज का डिस्कशन हम लोग ट्रायल कोर्ट जजमेंट में और एप्पलेट कोर्ट जजमेंट में देखते हैं, क्योंकि ये जो लैंग्वेज है और ये जो वो है वो ठीक से पढ़ना नहीं।
While dealing with the issue number 7, blood at page, internal page 26, para 37.
इस कागज को थोड़ा संभाल के रखिए। इसका पैरा नंबर
37.
36।
Internal page 26.
हाँ बताइए।
Whether the plaintiffs suppressed the real facts of their pleadings or not.
आप पैरा 35 से पढ़ेंगे।
On the perusal of the report, it appears that according to the pleadings of the plaintiff, Nanku Mahato had two sons, Rupan and Degan Mahato. Rupan and his wife died before Nanku Mahato in the state of jointness in quick succession in or about the year 1928, leaving behind only two daughters, namely Jasoda Devi and Tekni Devi, pro forma defendant number 8 and 9. So, pro forma defendant number 8 and 9 had no legal right, and according to them, after death of Rupan, his father Nanku and his brother Degan became the owner of Schedule A to C property by the rule of survivorship. At the same time, the plaint itself discloses in para 15 that the plaintiff viewing the situation got sale deed registered for Schedule A to C lands in their favor from the defendant number 8 and 9, who are daughters of Rupan Mahato. Plaintiff number 1 to 3 got two such sale deeds got executed by defendant number 8 and 9 on 17/6/69 with respect to Rupan's supposed undivided share. Now, from the very pleading of the plaintiffs, it becomes clear that the story of partition of Shamilat land among four sons of Baldev has been falsified by the above fact. So, there was no partition among the descendants of Baldev Mahato in the year 1928. So far, the joint lands of four brothers of Nanku are concerned. In such circumstances, descendants of all the members of the branch of Bhairot, Khaiman and Keher are necessary party, but in spite of the above assertions of the defendants, in para 6 of the written statement, the plaintiff took no trouble to amend the plaint and make them necessary party. Under such circumstances, the suit is defective for non-joinder of necessary party. As such, issue number 4 and 8 are decided against the plaintiff. Issue number 2.
This is on limitation. Which finding do you want?
37, Lordship, para 37.
उसी पेज में
आप पढ़िए।
Issue number 7. Whether the plaintiffs suppressed the real facts in their pleadings or not. According to the defendants, it is the plaintiffs have suppressed the real facts in their pleadings, and the defendants have claimed to send the real facts in their written statements. Both the plaintiffs and the defendants claim to have presented the real facts, and it is the general psychological behavior of the contesting parties, and these type of statements are of general nature. This issue has not much importance in deciding the main issue in this suit, so I do not think well to pass any finding on this issue. Thus, the above observation, this issue seems to be disposed of. Issue number 5. According to the defendants,
नेक्स्ट इम्पोर्टेंट इशू इशू नंबर 9 है ना, प्लीज पारा बताओ।
Paragraph 4.
यही main issue. If the Nanke would have died prior to 1956, then whether his daughter and daughter's son will inherit or not.
No, that is not the substantial question.
That is issue number 2, therefore we are agreeing.
No, that's right, but that is not the substantial question.
The plaintiff has challenged that the sale deed of 1977 executed by defendant number 6 and 7, they have no right to execute. Therefore, the Hindu Succession Act will come into play. If Nanku would have died after coming into force of Hindu
Sir,
Succession
ये
Act,
issue to decide हो गया Supreme Court से. हो गया ना decide?
नहीं हुआ नहीं है,
Okay,
ये
नहीं.
केवल
हो गया decide.
ये केवल रेफर करने
Okay.
का आपको परमिशन दिया जाए इशू नंबर 2, इशू नंबर
अब
9।
आप जजमेंट भी बताइए. इतना हम आपको बता दें कि डिसाइड हो जाएगा.
तो अभी तो रिसेंट आया है विनीता शर्मा केस, और
डेथ पहले हुआ है या बाद में हुआ है, इट इज इम्मटेरियल. पार्टीशन नहीं हुआ है तो नहीं हुआ, और जिस दिन उसका जन्म होगा उस दिन से काउंट होगा, बिकॉज शी एक्वायर्स द राइट बाय बर्थ. अगर पार्टीशन हो चुका है वो रीओपन तो नहीं होगा, लेकिन अगर पार्टीशन नहीं हुआ and the common
तो
system
open
has
होगा।
expired prior to 1956.
there is a specific finding of the trial court that there was no partition, previous partition.
That's right.
Then let the question which has been raised by me.
लेकिन
will come
नॉन
into
जॉइंडर
play.
वाला इशू नहीं है हमारा. सब्सटैंशियल क्वेश्चन ऑफ लॉ नहीं है. सब्सटैंशियल क्वेश्चन ऑफ लॉ, इफ वी रीड इट, it is in connection with the interpretation of documentary evidences exhibit 1 series. What is the impact? क्योंकि exhibit 1 series में there is a mention of previous partition.
Now let inter-se transaction between the parties is admitted by annexure 1 series.
So I just want to know what is annexure 1 series. इसमें होगा description ना. These are
That is the different sale deeds which are executed by parties in favor of other parties.
a list of exhibits and निकालेंगे.
We have already cited bullet AIR 1977 Patna page 59 on last occasion.
77.
है? नहीं, अगर नहीं है तो दे दें। नहीं दे देते।
हाँ, 1977 पट्टा पेज 59.
जी।
Yes, बताइए. Mutual transaction between two members is strong evidence of separation. ये जो सेल डीड से कब के हैं?
एक सेल डीड मेरा जो चैलेंज हुआ है वो 77 का है।
और ये जो एनेक्सर 1 सीरीज के
एक 1 सीरीज में अदर ट्रांजैक्शन है बिटवीन द पार्टी। लास्ट सेल डीड का वो तो दूसरा और सेल डीड हुआ है। प्लेट के पैरा 8 या 9 में स्पेसिफिक 15 में स्पेसिफिक लिखा हुआ है हु सेल सोल्ड टू हुम।
अच्छा,
पैरा 15 किया होगा। प्लेट में स्पेसिफिक किया हुआ है। Friends, we are referring para 15 of the plan.
Yes.
That after some years of the death of Degan, that is in or about the year 1968-69, the defendant started trouble and a move to lure the defendants, daughters of Rupan Mahto, that is pro forma defendants 8 and 9, to foster litigation by executing some sham sale deeds in their favor. Pro forma defendants and the plaintiff, seeing the sinister move of the defendants and the pro forma defendants, proposed to the plaintiff to obtain most formal deed of sale in respect of Rupan's supposed undivided interest in the lands described in Schedule A to C of the plaint, so as to silence the defendants and the whole world. The plaintiff, also viewing the situation, and though pro forma defendant 8 and 9 had no interest whatsoever in Schedule A to C lands of the plaint, agreed to obtain a formal deed of sale from the pro forma defendant 8 and 9, and accordingly pro forma defendant 8 and 9 executed two formal sale deeds of the sale in respect of Rupan's supposed undivided share on 17/6/69, both in favor of plaintiff number 1 and 1 to 3.
So this is referring to undivided share. Correct? It is not referring to previous partition.
Rupan's undivided share.
Rupan's undivided share.
आगे
So and the suit was for claiming 1/3 of Rupan's undivided.
No, Hemant's.
Hemant's.
Yes.
This is in connection with Rupan's.
Yes, sir.
Okay.
That finding the dishonest intention of the defendants, plaintiff number 5, sonless as she was, and had kept plaintiff number 6, the husband of plaintiff number 3, as Jamai, thought it meet and proper to transfer half of the land described in Schedule A to C of the plaint in names of her daughters and son-in-law, plaintiff number 1 to 4, and to retain half for herself till her lifetime. Therefore, she, plaintiff number 5, executed a sale deed in respect of some lands of Khata 17 and Khata 1/2 and 1/23 in favor of plaintiff number 3 and 6 on 28/5/69 and put them in possession. Subsequently, on 9/8/69, plaintiff number 5 executed another sale deed in respect of some lands out of Schedule A to C lands in favor of the plaintiff number 2 and 4 and put them in possession, retaining some lands for herself. Thus, the plaintiffs have joint title to the lands of Schedule A to C described in the plaint and have in peaceful, uninterrupted and continuous possession to the knowledge of the defendant.
These are all Exhibit 1 cities.
One city.
So how does it help you?
Therefore, when the substantial question formulated was, inter-sea transaction between the parties constitute the fact or the principle that there was a partition.
There is an explanation to this. They were of the view that in order to buy peace, these sale deeds were executed. This is the explanation for execution of the sale deed.
Explanation is there, certainly explanation is there, but they have sold this share.
Undivided share.
Undivided.
Undivided
Yeah.
share. There is no part. There is no legal part. The person who buys the property has got the right to partition. There is no bar under Hindu law in selling undivided share.
We are not challenging the sale deed executed by them. What we are challenging, that there was inter-sea transaction between the parties with respect to certain piece of land, share.
Yes.
Therefore, it shows that there was previous partition.
No, this will not show previous partition. If
Now-
one co-sharer is selling his undivided share to another co-sharer, that does not mean that if there is a recital in the sale deed that there was already a partition and I am entitled to this particular share, I am passing on this property to you.
77 है तो भीतर यही चाहिए। We are referring the तारीफ जायदाद से मुहैया, the property which is under sale. पढ़ो
कौन सा एग्जिबिट नंबर बताइए?
ये पीछे नहीं लिखा हुआ। This is the sale deed which has been challenged by the plaintiff
Okay. This has been declared to be null and void.
to declare the same as null
आप
and
उसको
void.
क्या देखना चाहते हैं?
उसका कंटेंट्स दिखा रहे हैं।
उसका कंटेंट्स भी नहीं देख सकते ना, इट इज नल
अच्छा,
एंड
और
वॉइड.
दूसरा सेल डीड देख लेते हैं।
एग्जिबिट लिस्ट में वन सीरीज करके लिखा हुआ है, उसमें लिस्ट में सब डीड का नंबर लिखा हुआ है.
दे देगा कोई नहीं।
खाली वन सीरीज करके लिखा है.
इसको देखो कहीं कोई होता है, समझ जाए, पढ़ते रहें।
सूट कब का है सर? 78.
We are referring the contents of sale deed of
सर एग्जिबिट वन सीरीज में सेल डीड ऑफ 12/2/1918
ये
एंड
91 का सेल डीड है, 26/10/1951।
सर 91 का सेल डीड से आपका 78 का सूट तो नहीं डिसाइड होगा ना.
Partition to till then, till today it has not been done. It is said by
जो
the
आप
plaintiff.
जजमेंट साइट किए हैं, that is the judgment in relation to the previous sale deeds executed, indicating that there was a partition.
From perusal of the statement made in para 50, your lordship will find that some of the ladies member of the family have executed sale deed in their favor, which is alleged to be paper transaction.
Maybe paper transaction, but we are
But
talking about
it is a
whether these transactions by itself can be a proof of previous partition. This is the question of
therefore, but I was referring the recital of the deed.
which deed and which exhibit. Deed का date बताइए.
Lead date is 26/10/1991.
Exhibit number क्या?
List of exhibit.
So list of exhibit में exhibit 1 and 1/A, it's sale deeds of 12/2/80.
एक तो 77 है, एक तो 91 है।
ये 70 है कि 80 है?
बेटी
20/2/80 को मार्क हुआ है, तो यहाँ पे ऐसा लिखा हुआ एग्जिबिट 1 and 1/A. सर आपको हम दे रहे हैं सारा एग्जिबिट 1 सीरीज, आप इसमें से टैली कर लीजिए एंड देन जस्ट
आराम से उसका रिसाइकल हाँ ठीक है उसका
सर ट्रायल कोर्ट के जजमेंट में पैरा नंबर 31 में सारे सेल डीड्स का जिक्र है।
जी,
कौन किसको
जी।
भेजा है?
नहीं वो तो जिक्र है
हाँ।
लेकिन तो हम सेल डीड से दिखाना चाह रहे थे कि whether they have recited partition was done prior to execution of the sale deed. तो ठीक है 1
We are only concerned with partition of the portion allocated to
Cayman.
खेमन में। तो खेमन में तो का कोई पार्टीशन हुआ है कि नहीं, उसी से मतलब होगा आपको प्रीवियस पार्टीशन। अगर वैसे कोई प्रीवियस पार्टीशन है उससे तो कोई मतलब नहीं। They have to make specific statement in this.
चारों भाई में हो गया बंटवारा ना बिफोर सर्वे। This
वो
is the
दिखाएं।
case made out in the play.
वो दिखाइए खेमन में तो का प्रॉपर्टी को लेकर कभी कोई पार्टीशन, बिकॉज खेमन में तो डाइड इशूलेस। खेमन में तो यस खेमन में तो डाइड इशूलेस and therefore their case was that Cayman Mehta died issueless, so his property devolved upon the remaining three brothers.
Living behind a daughter,
Yes.
Patni, and his son Sukar Mahto. Oh, his husband Sukar.
Yes. So their case was it devolved upon the brothers. Brothers of Cayman Mehta.
If they would have joined, then the matter would have been otherwise. But if he is separate, then it will not go to brothers. लेकिन अगर joint है तो brothers हो जाएगा. If one die, intestate or living behind no heir, prior to 1956 or even after 1956. It will go to possessors. एमिकेबल पार्टीशन का जिक्र है इसमें. That
Between
is-
whom? Amongst whom? Amicable partition amongst whom?
What? द्रुपद मतों से दीगन मतों दोनों बिरादरान आपस में बाखुदा बंटवारा कर लेकर अपने अपने हिस्से तख्ती पर कार्य एवं काबिज दखल हुए. He exhibit 1 by C.
Exhibit 1 by C. क्या recited है इसमें? This is 7869
It is said it.
by Tipni Devi in favor of her daughter
Yes.
Mahalya Devi and Kalya Devi.
I am giving the detail. This is they said it executed by Tipni Devi in favor of Srimati Mangli Devi,
And Kalya Devi.
Srimati Kalbi Devi.
That's all.
बस ये दो बात.
So what is the recited?
Yes. Recital is that. जो पूरा पढ़ो.
रुकन महतो और दूसरा देगन महतो सोहर मुकीर अपना वारिस छोड़कर
वफात पाए.
बरसे मतरूकी पर
उनके
उनके दोनों पेशदान आपस काबिज दखलकार हुए. बाद में रुपन महतो व दिगन महतो दोनों बरिदराम आपस में बाखुदा बंटवारा कर लेकर अपने अपने हिस्से तफसील पर कायम काबिज दखलकार हुए.
रूपन एंड देगन का पार्टीशन है. आगे
दखलकार हुए.
ये जो बेटी है ना वो
सर ये जो चार भाई है ना
देगन मतों की बेटी है.
ठीक है. रूपन एंड देगन. She
Okay.
says they say that Rupan and Degan got the
बेटी किसको?
partition.
बेटी किसको है? मंगली दो अख्तर श्री देगन मातो
ठीक.
और श्रीमती कैली दो अख्तर ड्रेगन मातो.
ठीक.
देगनी मतों को.
तो ये जो दो लोग हैं रूपन एंड देगन के बीच पार्टीशन हुआ था. इसमें तो कोई डिस्प्यूट ही नहीं.
इसका डिस्प्यूट यहाँ नहीं है केस में. बट वी वांट टू शो that there was inter-sea transaction between the parties.
कौन सा पार्टीज? 4 persons, 4 brothers.
4 brothers.
ठीक है. अगर मान लीजिए चारों भाई के बीच में पार्टीशन हो चुका, right? Then you say that there is no question of devolution of property to the brothers of the क्या नाम है? कौन सा? खेमन. Right? आप हमको ये दिखाइए कहाँ है कि खेमन और इनके भाइयों के बीच पार्टीशन हुआ. अगर खेमन और इनके भाइयों के बीच पार्टीशन हुआ है ना, then the story is different. लेकिन खेमन और इनके भाइयों के बीच पार्टीशन की अगर कोई बात नहीं है, तो फिर पार्टीशन होगा.
Let us see the finding of the trial court on issue number.
Let's say
इसके नीचे का पेपर लगवाना. we were referring para 40, issue number 9.
Yes. What was issue number 9?
Issue.
Whether the sale deed is legal, valid, and
Yes.
impugn sale deed.
Yes. And while dealing with this, the succession, point of succession has been taken note by the judge.
Let's see.
This is the most important issue of the suit. According to the plaintiff, defendant number 6, daughter of Nanku Mato, and defendant number 7, grandson of Nanku Mato, who are pro forma defendant in this suit, who had no right in the property of Nanku in Schedule A, B, and C of the plaintiff. According to them, Nanku Mato died in the year 1952 in the state of jointness with his son Degan, leaving behind his only son Degan Mato and two daughters, Vedani and Lakhya, and therefore Degan Mato succeeded the entire properties of his father by right of survivorship as sole surviving co-parcellor and came in exclusive possession of Schedule A to C lands of the plaintiff. Vedani is a pro forma defendant number 6, and Lakhya died as widow, leaving behind her only son Harku Mato, pro forma defendant number 7. Thereafter, Degan alone came on paying rent in Schedule D lands and came on obtaining rent receipts. Degan also came on contributing his share of the lands for Khata number 17. After vesting of Zamindari, the rent for Khata number 17 used to be paid jointly by contribution by all owners of Khata number 17, but sometimes after the Karamcharis and the Panchayat Sevaks
इसी 17 खाता का पार्टीशन मांगा था.
have made a mess of everything and have been accepting proportionate rent from one or the other owners and have been issuing rent receipts without sense of proportion. But nonetheless, the owners are paying rent according to their respective shares. According to the plaintiff, as Nanku Mato died in the year 1952, much before passing of Hindu Succession Act in the year 1956, Vedani Devi and Lakhya Devi, or son of Lakhya Devi, namely Harku, did not succeed any right, title and interest of the property of Nanku Mato. As such, the two sale deeds executed by defendant number 7 and 8 in favor of defendant number 1 to 5 on 5577 are illegal, void and fit to be declared null and void, so resulting in the effect of cancellation of the two sale deeds. On the other hand, according to the contesting defendants, Nanku Mato died in the year 1957 in the month of Ashwin, leaving behind his two daughters, namely Lakhya Devi and Vedani Devi, and the heirs of Degan Mato, and also the heirs of Rupan Mato. Further, according to these defendants, it is false to say that by the plaintiff, the defendant, that Rupan died in the year 1928. As a matter of fact, Rupan Mato died in the month of December 1956, leaving his widow and two daughters, namely Jashwa Devi and Tekni Devi, who are defendants in this suit. These defendants most humbly and respectfully submit that Degan Mato died in the year 1954. So both the sons of Nanku Mato died during the lifetime of their father. So according to these defendants, the sale deed executed by defendant number 6 and 7 on 5577 in favor of defendant number 1 to 5 are legal, valid, genuine and for consideration. Now I have to scrutinize the weight of testimonies and documentary evidences of plaintiff defendant to reach the particular finding. PW1 has proved a sale deed, which is Exhibit 1. PW2 has proved the rent receipts, which are Exhibit 2 and 2 by A. PW3 has proved the sale deed, which is Exhibit 1 by A. PW4, Muswat Tipni, widow of Degan Mato, is one of the plaintiffs in the present suit, has got herself examined as PW4. She has given her age about 50 years in the year 1980 when she was examined. When she was examined on 13 to 80. So her date of birth will come sometime in the year 1930. Hence she has stated in her cross-examination in para 7 that she married with Degan when she was 15 or 16 years old. So according to her above statement, she was married to Degan sometime in the year 1945-46. She has also deposed in para 12 of her cross-examination that her that age of Jaswa Devi, who is admittedly the daughter of Rupan Mahato. Jaswa Devi was 17 years in the year 1980 on the date of her examination in court. So age of Jaswa Devi was 17 or 18 years in the year 1980. This logically proves that Jaswa was born in the year 1962, which goes to prove that Rupan Mahato, sons of Nanku Mahato, was alive in the year 1962. And whereas Moswat Tiffany deposed in para 8 that Rupan died leaving behind two daughters, PW4 further deposed in para 1 that when she came to her sasural, she had not seen her Bhaisur, elder brother of her husband, but heard he had died. So according to her statement, she stated in para 12 of a cross-examination by giving the age of Jaswa Devi as 17 or 18 years, while admittedly Rupan Mahato and Degan Mahato were full brothers, and Rupan Mahato was Bhaisur of Moswat Tipni. And if Rupan died after 1962, then certainly she had seen her Bhaisur because her marriage took place in the year 1945-46. As such, it proves that Rupan's daughter got the interest in the lands of Khata number 17 as well as Khata number 1 by 2 and 1 by 23 of Mauza Balhara, while the pleading of the plaintiff is that the plaintiffs have stated in para 10 of the claim Rupan died in the year 1928, while the plaintiff number 5, Usman Tipni, has clearly proved that Rupan Mahato was alive at least in the year. So there is a great difference regarding the time of death of Rupan Mahato. So it is the case of plaintiff that Rupan died in the year 1928 has been falsified from the statement of PW4. And at the same time, it has also been submitted that when Rupan was alive, at least in the year 1957, then there is no question to give the fire in the mouth of Nanku Mahato by Degan Mahato, while admittedly Rupan Mahato was the eldest son of Nanku. So according to
You just come to the finding, इतना क्या evidence हम लोग को पढ़ना?
नहीं एविडेंस एक ही एविडेंस इंपॉर्टेंट है एग्जिबिट 4 वो दैट इज डेथ रजिस्टर brought under police manual
Okay.
that has been reversed by the appellate court. Exhibit 4 का reference
So वो substantial question of law नहीं.
नहीं है हम दिखाना चाहते हैं कि डेट ऑफ डेथ ननकू का क्या था ईयर ऑफ डेथ क्या था
1951 का finding तो आया है 1951.
नहीं अभी
अपीलेट कोर्ट में आया।
मेरा डिफेंडर का कहना है कि 50 से 57 just now my friend has ready to evaluate PW4 का स्टेटमेंट जो है
सर आप ये पैरा 44 में आप पैरा 44 में of the trial which is discussing exhibit 1.
now let me consider the documents on record. Exhibit 1 is the sale deed dated 13/6/70, which was executed by Name Mahato and others who are descendants and heirs of Keher Mahato, Bhairav Mahato and Nanku Mahato, who sold jointly some lands under Khata number 17. There is a recital. 80 डिसमिल के मध्य 20 डिसमिल खरीद की जमीन रकम 4 आना हर प्लॉट में. This shows that partition had taken place.
Had not taken place.
Had not taken place among the recorded tenants of Khata number 70, but vendors Bhairav Mahato, Narayan Mahato, Guna Mahato and Latu Mahato were not made party. Exhibit 1 by A also does not prove the story of partition. Similarly, 1 by B does not prove story of partition. 1 by D and 1 by G also support the case of defendants. On the other hand, Exhibit 4,
this is the important document.
Exhibit
A, which is a sale deed of 5/5/77 being executed by Bedini Devi, daughter of the late Nanku Mahato and Harku Mahato. Daughter's son of Nanku Mahato sold the lands under Khata 17, that is Kabjawari land of Nanku Mahato, and also the Shamilat lands. In this respect, it is very important to mention that the defendant had filed Exhibit A by 6 and C by 1, two certified copies. Exhibit A by 6 is certified copy of Kevala number so and so dated 19778 and Exhibit CY1 is certified copy of judgment in title partition number so and so. These documents, however, does not bear the importance of being the deciding factor of the suit because the present suit, the most important point was period of death of Nanku Mathur as to whether Nanku died in the year 1952 or in the year 1957. So far the fate of this suit is concerned, Exhibit A by 6 and C by 1 are such documents which could not have been filed much before either by the plaintiffs or by the defendants. By obtaining certified copies. So this old suit remained undisposed of, while the last defense witness examined on 2280. So far, more than 8 years, the suit remained undisposed of. Ultimately, on 3688, the learned lawyer for the defendant filed a petition and submitted a copy of Exhibit A by 6 and C by 1 could not be obtained. So this old suit may be disposed of without the above exhibits. Third, both sides on above point, learned lawyer of both the parties agreed and argued the case. Order sheet dated 3688 and 4688 bear the above fact. Further, I find that Exhibit D and D by 1 are rent receipts issued on so and so date.
These exhibits, one series with which we are concerned, where are they showing previous partition? Rather, multiple people are joining to execute the same. They are not exhibiting previous partition. They are not exhibiting previous partition. आप एक भी सही से बताइए कि previous partition की कहानी. Now there is a clear finding that he died after 1956. The appellate court records that he died.
I was trying to show one document, the Exhibit 4.
Exhibit 4 नहीं देखेंगे ना सर.
That is the
Exhibit 1
death register.
Exhibit 1 series, sir, that is not the substantial.
Exhibit 4, date of death, to show date of death of Nanku.
Sir, that is not the substantial question of law.
Yes, that is.
If it is not the substantial question of law, we will not pick up one exhibit and decide on that. Whether in view of documentary evidences Exhibit 1 series, being several decisions showing transaction between the parties, establishing the factum of previous partition, and showing that such partition being acted upon, the claim for partition for title is barred by the principle of estoppel, waiver. This is the question. That is not showing previous partition. Because you are claiming previous partition only in connection with Cayman's property. No, you are claiming partition only with respect to Cayman's property. 1/3.
I am not claiming that. I am objecting that.
You are objecting.
The relief number 1, in which 77D has been challenged.
आप हमको एक बात बताइए, क्या पार्टीशन का रिलीफ दिया गया है? नहीं दिया गया है?
नहीं दिया गया है, लेकिन रिलीफ ही अमेंड करके लाए हैं.
नहीं, पार्टीशन का रिलीफ तो नहीं मिला ना.
नहीं.
तो इस सब्सटेंशियल क्वेश्चन ऑफ लॉ का हम क्या करें? आप बताइए. When no relief has been given to the plaintiff, they sought partition. No relief has been given of partition. तो इस particular substantial question of law का क्या relevance? देखिए आप चेक करिए, appellate court में दिया है क्या? सूट तो डिस्कस हो गया. आपको partition मिला था क्या?
नहीं.
3 और 4 पॉइंट है जो अपीलेट कोर्ट का, उसमें ऑलरेडी इनका केस यही है कि 57 में ननकू महतो का डेथ हुआ और मेरा केस था 52 में, तो डिसाइड होगा 51 में 1951 में पुलिस रजिस्टर से. That was the main question. That is only decided.
But substantial question has not been formulated. Admittedly, no substantial question has been formulated on the point of Nanku's death and succession by other heirs and इनको रिलीफ पार्टीशन का नहीं मिला है. पॉइंट नंबर 5 में और कंक्लूड कर रहा है अपीलेट जजमेंट.
They are entitled to the relief as claimed.
बस. नहीं वही तो नहीं मिला ना, रिलीफ तो नहीं मिला ना, ओके। वही लास्ट पैराग्राफ में देखा जाएगा, entitlement to the reliefs asked for. Though that, not that कि preliminary decree be prepared
कुछ
or
नहीं, वो तो
something.
पार्टीशन का रिलीफ में तो प्रिलिमिनरी डिग्री बनता है ना।
बनता है।
तो रिलीफ एज स्ट्रेट फॉर मतलब देयर इज रेफरिंग ओनली टू द सेटिंग असाइड ऑफ द सेल एंड नथिंग मोर।
Yes, yes. अमेंडेड रिलीफ के बारे में कहीं कोई फाइंडिंग नहीं है ना ट्रायल कोर्ट का ना अपने
नहीं कोई फाइंडिंग नहीं। और ये एग्जिबिट ए सीरीज से तो कहीं भी कुछ पार्टीशन की बात एस्टैब्लिश नहीं होती।
नहीं उसमें भी है कहीं कहीं कि एमिकेबल पार्टीशन में बट
Among
शेयर
whom?
हैव बीन यस शेयर हैव बीन सोल्ड 1/4 1/2 1/5
तो ठीक है जितना उनका अपने हिसाब से जो शेयर अपना
हाँ।
बना और जो इनका रेंट रिसीट्स है वो भी जॉइंटली पेड है, कभी जॉइंटली रिकॉर्डेड है, उसमें भी कोई क्लियर कट नहीं है किसके नाम से कितना है। तो when we see exhibit 1 series we cannot ignore exhibit 2 series also by which the different rent receipts were issued in favor of various persons।
इंडिविजुअल पर्सन
यही है बस, आपको क्या बोलूं बताइए।
डिसाइडेड हो गया पॉइंट जो था हमारा सेल नल एंड वाइड करने।
आप तो उसी से खुश हैं,
ये
आप बताइए।
नल जो हमारा रिलीफ था that had been decided in matter by appellate court.
That's it।
That's it.
Regarding null and void,
Null and
पार्टीशन दिया है क्या आपने?
no
नहीं दिया है ना पार्टीशन। तो सब्सटेंशियल क्वेश्चन ऑफ लॉ नंबर 1 का हम क्या करें? पढ़िए।
नंबर 1 पार्टीशन शूट का वो तो डिसाइड होना चाहिए था पहले ट्रायल
हाँ डिसाइड होना चाहिए था, उससे मतलब नहीं
Trial
है
court
कि
में।
सब्सटेंशियल क्वेश्चन ऑफ लॉ नंबर 1 करेंगे। हम अपने एक चार दीवारी से बाहर नहीं निकलेंगे, सब्सटेंशियल क्वेश्चन ऑफ लॉ के बाहर नहीं निकलेंगे।
whether there is a partition
यस एग्जिबिट 1 सीरीज से कहाँ पार्टीशन प्रूव होता है?
नहीं
नहीं होता है।
नहीं
Then under such circumstances कुछ भी तो ऐसा हमको नहीं दिख रहा है कि there was previous partition।
इसका
Previous partition between
Four
Rupal and Devan is admitted, there is no doubt, but that is not sufficient।
since specific relief has been not granted which has been brought on record by amendment
By amendment,
therefore
no,
the
it has been
matter requires reconsideration by the trial
no, why should we say?
as well
ऐसा कुछ तो है ही नहीं।
as well not
And plaintiff is not agreed,
plaintiff will not agree
so उनको रिलीफ चाहिए था ना 1/3 शेयर, उसका प्रिलिमिनरी डिक्री होता, फिर उसका तख्ताबंदी होता,
तख्ताबंदी।
वैसा तो कुछ नहीं है।
कुछ नहीं। केवल एक लाइन दिखाना चाह रहे थे रिलीफ शॉर्ट फॉर बाय द प्लेंटिफ इन द प्ले रिलीफ ए इट बी adjudicated that since Nanku died in a state of jointness with his son Degan who succeeded him by right of survivorship in the year 1952 and performer defendant number 6 and Lakshya Devi and after her death performer defendant number 7 had no right title interest over the land possessed jointly by Nanku and Degan. Nanku and Degan का specific relief मांगा गया था. Since Nanku had died prior to 1956, Therefore, his daughter and daughter's son will not inherit. Even according to the relief sought for and the finding and the substantial question formulated कि रूपन डेगन का पार्टीशन हो चुका था.
Rupan and Degan का partition.
रूपन एंड डेगन का
Nanku was father of Rupan and Degan.
Nanku is the father. Nanku is the father. And therefore the substantial question formulated that the documentary evidence exhibit 1 series being several decisions showing transactions between the parties, establishing the fact of previous partition and showing that the partition being acted upon. The claim of partition and for title is barred by principles of estoppel.
Previous partition is not proved by Exhibit 1 series. It is not proved by, it cannot be proved by Exhibit 1 series. And
Yes,
if the
specific-
previous partition is not proved by Exhibit 1 series, then under such circumstances there is a question of estoppel waiver.
What I want to submit is that this is also in the mind of the plaintiff that Rupan Degan का partition हो चुका है. Therefore, the relief sought for that death हुआ ननकू का अगर 1951-52 में, तो his daughters will not inherit. इसीलिए ये relief number 1 दिया गया.
तो if his daughters will not inherit, जो भी सेल डीड इन्होंने चैलेंज किया था वो तो सेट असाइड हो गया. तो उनका तो रिलीफ which was relatable to this has already been granted. उनका वो जो सेल डीड चैलेंज किए थे, इसीलिए ना ये सारा कहानी चल रहा था कि it was jointly owned and possessed by Nanku and Degan, and because Rupan had died earlier.
And after death of Nanku, Degan alone.
And after that he came in exclusive possession of it. So ultimately the sale deed which was executed by the daughter, which was under challenge, that has been set aside. तो उसका जो relief
By the appellate court. By the appellate court.
Yes. Certainly by the
Yes.
appellate.
Yes.
So that relief and the connected relief in connection with the relief number 1.
लेकिन partition का कोई relief को मिला ना, which has been brought into record by amendment.
Partition का तो कोई relief नहीं मिला है उससे. और Exhibit 1 series से कोई भी ऐसा recital नहीं पता चल रहा है कि जिससे पता चले about previous partition.
Previous partition by Mead-Self.
Previous partition by Mead-Self.
Amicable partition सब sale deed में बोलता है.
Amicable partition देखिए, अगर मान लीजिए amicable partition भी होता है, and they are separated in every way, so that will be accepted.
Yes.
But if, right, अगर मान लीजिए सबका म्यूटेशन हो गया, सब लोग अलग हो गए, किसी को ज़्यादा मिल गया, कम मिल गया, इतना नहीं मिल
उनको
सकता।
evidence में आया है, separate rent receipt.
नहीं, separate नहीं, वो evidence में आया है कि jointly नाम से है rent receipts, कभी कोई देता है, कभी कोई देता है, लेकिन किसका कितना शेयर है वो डिफाइन नहीं है। ये आया है एविडेंस।
हाँ, proportion तो है।
हाँ, प्रोपोर्शन है, सबका अपना अपना, लेकिन कौन कितना रेंट दे रहा है, कौन किसको रेंट दे रहा है,
ये एविडेंस में आया है, प्लीडिंग एंड एविडेंस है जब
सब नहीं।
I don't know सबके टाइप।
आपको कुछ बोलना है?
नहीं, हमरा वही तो इनका जब मेरा मेन रिलीफ था वो हमको मिल गया by declaring that the death had been done in the year of 1951. Hence, there is no question of inheritance of the daughters. Hence, they now right to sell the land in favor of the
वो तो
dependent.
फाइंडिंग आपके फेवर में ही है।
और वो फेवर में उसको हमको तो हम तुम फेवर में तो काय कर बहस करें उसको, उसमें फेवर में अपीलेट कोर्ट का जजमेंट में।
Give me 2 minutes. रूपन महतो एंड देगन महतो के पार्टीशन का कोई फाइंडिंग तो नहीं? The partition that we are looking at is the partition between Rupan Mahto and Degan,
Yes.
correct? Right? Exhibit 1 series उसी के लिए.
वही
And it was a case of the plaintiff that they constituted joint family, Hindu undivided family, and there was no partition. Give me some time, I will dictate it in the second round. तो और ध्यान से देख के इसको डिक्टेशन हम सेकंड हाफ में देंगे. पर एक तो सब्सटेंशियल क्वेश्चन ऑफ लॉ डिसाइड करेंगे.
कोर्ट फीस
कोर्ट फीस.
May I take you?
हाँ sure. इसका प्लेट और डिटेल स्टेटमेंट आना चाहिए. ये अलग नहीं करना है, खाली फ्लैग करना है.
For hearing from Substitution list item 2, second April 23 of 1999.
Lordship, in this case, I am praying for 1 week time on behalf of respondent number 1, my lords. Yesterday only has given me wakalat now. The earlier advocate, my lord, as per the instruction, has left the practice for Mr. Lalji Sai. Has given the wakalat number to appear on this day.
On behalf of respondent number 1.
My lords, MD Nasimuddin, lordship.
Earlier, he was also representing respondent number 2, but respondent number 2 has not been respondent number 2 not 3.
Sorry?
Respondent number 2 के लिए मतलब अभी भी कोई अपील नहीं है, because हाँ एक्चुअली क्या है ना मैडम ये respondent number 1 happens to be the son of respondent number 2 and respondent number 2 is dead. Respondent number 2 is dead.
Regarding whether he's alive or not, respondent.
आपको respondent number 1 ने बता दिया.
Yes, respondent number 1 has been the
Respondent number 2 is the son of respondent number 1. तो उन्होंने आपको ये नहीं बताया respondent number 2 की भी कैसे होगी.
He has only started to appear on his behalf, my lord, and regarding the condition.
भाई का नहीं बताया. मतलब बेटे को बाप बेटे को एक दूसरे का मरने से
My lord, since I have not asked or he has not revealed.
You have his number?
Yes, my lord, I have.
पूछ के बताइए. क्योंकि अगर किसी का डेथ हो गया है तो रिकॉर्ड करेंगे.
Yes, my lord.
ठीक है. Respondent number 2 बोल रहे हैं ना डेथ हो गया. अब थोड़ा बताइए बता के. Notice validly served to respondent number 4. Respondent number 3 has died. उनका तो substitution हो चुका है शायद. 1 and 2 had appeared. 1 and 2 both had appeared. Are you informed that respondent number 2 has expired?
I'm just taking section.
Please take it. Super, just 10 minutes to take up.
For final disclosure, attempt 4, second appeal 190 of 922.
इसको मत दे. Post on mind.
Permission item 6 contains 46 of 925.
Lord, he has died
Yes, sir.
in the year 2000.
2000.
Yes, my lord.
2000. उनका legal years and successes का details इनको दे देंगे.
I'll provide.
लाइव सेटिंग का फाइल पास होगा. Counsel for the parties are present. Counsel for the appellant has submitted that respondent number 2 has expired during the pendency of this case. The learned counsel for the respondent has taken instructions from respondent number 1 and has confirmed that respondent number 2 has expired and has further stated that he expired in the year 2000. Volume को वकालतनामा देखिए. Volume 2 का वकालतनामा का फाइल. तो हजार में फाइल.
2000 में उनका डेथ हुआ.
Apparently, the appeal is abated as against respondent number 2. डेथ सर्टिफिकेट आपको रिकॉर्ड करना
डेथ
है।
सर्टिफिकेट उस हैव रिक्वायर्ड ये सेट की अकॉर्डिंग टू सम मुस्लिम लॉ वैसा डेथ सर्टिफिकेट नहीं था बट कोई रजिस्टर है जहाँ पे वो देख के डेट वेट में वी विल इन्फॉर्म यू। आई टेक द कंप्लीट
You put it on
details
record.
my lords
The
complete
learned
data.
counsel for the, however, the learned counsel for the respondent number 1 has submitted that he should file the document in connection with death of respondent number 2
Details my lords.
and also provide the names of legal heirs and successors of the respondent number 2. अपडेट कर दिया आपका नंबर। एफिडेविट में आप ये भी डाल सकते हैं as to whether and when you can say that they are knowledgeable. क्या है ये partition suit है क्या?
ये हमारा सूट फाइल हुआ था for 3 prayers. The first prayer was for declaration of ownership. The second related to the cancellation and declaration of null and void of a gift deed. And the third prayer was for eviction of respondent number 3.
ठीक है, we have no option but to adjourn. But when should I post it?
Now I'll pray for 2 weeks now for filing.
ध्यान से देख समझ के फाइल करें।
So I'm praying for the permission to file wakalat on behalf of respondent number 1 lord. Since
You file it, you don't need the permission.
there are chances that registry will not accept it because earlier also some advocate were appearing.
Mr. Nanavati.
Amitesh Kumar, yes.
Amitesh Kumar Yasin has submitted that Mr. Raji Sahai, who had entered appearance on behalf of respondent number 1 and others, has left.
Ladies, I am appearing on behalf of D.
For 1 lord, respondent number 1. One
You
and
have fresh wakalatnama on behalf of respondent number
3.
3, who was appearing on behalf of respondent number 1,
1 and 2
has
my lord, 2 has
practically
died. So yes.
has practically left practice,
My lords.
and therefore he may be permitted to file fresh wakalatnama on behalf of respondent number 1. Permission is advised.
But one, if I may be permitted to make, I have filed an interlocutory application proposing additional substantial.
अभी तो आपका सूट अवेट करेगा कि क्या करेगा ये
ठीक।
तो उसके पहले तो नहीं डिसाइड कर सकते हैं। इसमें क्या है? अच्छा, इसमें डेट आपको 2 वीक्स का टाइम चाहिए। We can post it on 18 September.
After filing wakalatnama, my lords, if
आप अभी तक किसको फाइल?
the petitioner, the appellants may be directed to serve the entire
नहीं,
respondent.
आप उसका अभी दे दीजिए भाई। आपको रिकॉर्ड पढ़ना है तो रिकॉर्ड ही रहने दीजिए। इसके लिए चिंता करनी
Of the lords.
ये
Item 6, contains Bill 46 of 2025.
On the last occasion, there was direction upon the opposite party, my lord, opposite party number 3, state my lord.
मिला कि नहीं आपको?
No, my lord.
नो, कहाँ है आपका डॉक्यूमेंट? हाँ?
My lord, earlier they have sent the letter without administrative department to your lordship. And as on that, we have seen the instruction from the department concerned with regard to sending the letter, your lordship, pursuant to the affidavit filed by the GIADA, my lord. We have a clear-cut instruction that no, as on date, any letter has been received from the GIADA.
बिहार के वकील कौन? कौन?
Mr. Bardhan, sir.
आप एफिडेविट पढ़ सकते हैं। You put it on affidavit. that you have not received it.
My lord, today,
आज नहीं, इसे आप फिर करें।
next week, my lord.
Next week करें। Because that has to be placed on record that you have not received it. लेकिन इनका affidavit में था that you have received
ये
it.
भेजे हैं my lord, they are only playing with the latest my lord. None of the document has ever been sent through proper channel my lord.
ये तो बोलते हैं कि एडमिनिस्ट्रेटिव डिपार्टमेंट से भेज दिए।
नहीं, अभी इनका है कि हम इंडस्ट्री को भेजे।
सेक्रेटरी इंडस्ट्रीज डिपार्टमेंट।
माय लॉर्ड, अभी वो इंडस्ट्री को भेजे हैं और इंडस्ट्री हमको भेजेगी फाइनेंस। और ये ऑल टाइम जो है हमारा अकाउंट माय लॉर्ड, अपोजिट पार्टी नंबर 3 माय लॉर्ड इज कीनली since the order has been passed to look into the matter, therefore he has keen eye with regard to implementation of the order, your lordship, without communicating any letter to our accountant officer, my lord. They are submitting
इनको they are sending it to the secretary's industries department.
my lord.
इनको भेजना किसको?
इनको भेजना है वहाँ पर, ये भेजेंगे अभी प्रॉपर चैनल वो एडॉप्ट कर रहे हैं। अभी इंडस्ट्री को भेजेंगे, इंडस्ट्री फाइनेंस को भेजेंगे।
तो ये तो सेक्रेटरी इंडस्ट्रीज को भेज दिए।
हमारे पास नहीं है, फाइनेंस को नहीं है, और बिना फाइनेंस के अप्रूव का
तो
करेंगे।
अभी इसका मतलब आप ही के दूसरे हाथ में है।
माय लॉर्ड,
मतलब सेक्रेटरी इंडस्ट्रीज डिपार्टमेंट
सेक्रेटरी इंडस्ट्री के पास ही भेजे हैं, इनका ही स्टेटमेंट है माय लॉर्ड। हाँ,
तो भाई सेक्रेटरी इंडस्ट्रीज को भी तो आप ही ना।
माय लॉर्ड, हम ही रिप्रेजेंट करेंगे।
तो सेक्रेटरी इंडस्ट्रीज के पास आया है तब तो आप उसको आपके पास आएगा ना।
माय लॉर्ड, डॉक्यूमेंट के साथ हम फाइनेंस से इंस्ट्रक्शन लिए हैं माय लॉर्ड, यही डायरेक्शन था कि आप फाइनेंस से इंस्ट्रक्शन ले लीजिए।
अच्छा ठीक।
फाइनेंस से इंस्ट्रक्शन ले
तो
लीजिए।
सेक्रेटरी इंडस्ट्रीज को सारे डॉक्यूमेंट्स मिला है कि नहीं?
माय लॉर्ड, ये तो नेक्स्ट वीक रखती है।
ये कौन मतलब
हमें बताएंगे।
At the request of learned counsel for the state, close this case on next week. Friday को कर दे। Friday को रख दे। Friday छुट्टी तो नहीं है।
फ्राइडे छुट्टी है हमारा।
इस
फ्राइडे
कल छुट्टी है।
हाँ ठीक है, Friday को 12 तारीख को।
From table is for item 1, second appeal 1 of 1999.
Sought password of Mustafa is to argue. Order number 7, order dated 11/7/2022. My lord, in paragraph 4.
तो आप बोल रहे थे ये ऑलरेडी डिसाइडेड है।
हाँ, issue decided है।
रिस्पोंडेंट कहाँ है? Who is for the respondent?
Mr. Rajiv Ranjan Tiwari.
Where is he? आप बोल रहे थे जजमेंट से कवर्ड है ये केस।
हाँ, covered. Most one है. Any judgment.
According to you, there is no dispute on title.
There is a
Then
dispute. There is a dispute of title,
and therefore, the suit for injunction was not made.
not maintained.
Para 15, I read.
Para 20 law.
Para 15, 20.
Para 15. Yes. Yes, para 15 and para 20 also.
Only there are 15.
It cannot thus clearly be seen that this is not the case where the plaintiff appellant can be said to have a clear title over the suit property, or there is no clause on the plaintiff's appellant's title over the suit. The question in for one which requires adjudication after evidence is laid in question of fact and law are the decided. And 20 also Lords.
Excellent. Now, the first substantial question of law is keeping in view, please read it. Ready?
The main important substantial question of number 2 Lords is the suit for permanent injunction is maintainable in the fact in circumstance in the present case where no declaration title has been sought for his defendant.
Now, you are the defendant.
I am the defendant. The plaintiff filed title suit. Praying during
Plain
that
written statement with you. Title suit में क्या हुआ?
suit has been decreed against which the present appellant filed appeal. Appeal was also dismissed against which this appeal has been filed.
Suit was dismissed.
Suit has been decreed.
Decreed. Okay. So the suit stands decreed. And therefore your case is that the suit itself was not maintainable. As there was a dispute in connection with title.
There is a cloud of title.
There is a cloud of title. So you have to demonstrate cloud of title.
Yes.
Let us see from the accused judgments itself.
Yes.
Plain written statement on 4 value.
Issue number 4. Para 10 Lords.
Of the trial court judgment.
Of the trial court. Para 10. The issue number 4 is the plaintiff entitled to get a decree for grant of permanent.
पहले हम लोग para 8 देखते हैं.
Para
Para 8 is the issue frame.
Para 10 में issue frame.
The learned trial court appellate. Para number?
Para 10 Lords. On the basis of the pleading, the party with their consent, the following issues have been framed in the suit for adjudication on recast.
आप किसके
I'm corresponding.
बैठे.
Issue number 4 is the plaintiff entitled to get a decree for grant of permanent injunction against the defendant number 1 to 4 as claimed.
First, issue number 3 का क्या decision?
Is the suit barred by section 34 of the specific relief code? It is in favor of the plaintiff Lords.
What is the, let us see what is the finding.
Yes.
This is issue number.
Issue number 3.
Para 38.
Issue number 3, para 38 Lords. The learned lawyer appearing on behalf of the plaintiff has submitted that as per the provision of laid down under section 38 of the Substitution relief, it should be 34. Relief Act, the plaintiff is legally entitled to get a decree for grant of permanent injunction against the defendant number 1 to 4 without seeking relief for declaration is titled over 2,185 share in the disputed time. He submitted that perpetual injunction can be granted without declaration of title. He submitted section 34 of the Special Relief Act does not bar the present suit. He submitted that the court can grant relief if the plaintiff is not suitably drafted for the ends of justice. He submitted that in the present suit, right title interest in possession of the plaintiff over 2,185 shares has been fully proved. Hence, the period of the plaintiff for grant of perpetual injunction can legally be allowed. The learned lawyer appearing on behalf of the defendant has submitted that the present it is barred under section 34 of the Special Relief Act because the plaintiff is out of possession from 2,185 shares in the disputed time. The argument of the learned lawyer has not force because the plaintiff is coming in peaceful possession shares since the lifetime, the time of Mahesh Rao, and he is coming in continuous peaceful possession over the same since 8/1/1979 when the period of lease of the defendant number 1 expired. The learned lawyer appearing on behalf of the defendant has cited the decision reported in AIR 1977 was submitted that relief for grant of permanent injunction in this suit cannot be allowed because the plaintiff is out of possession of the disputed land. The argument learned lawyer for defendant number 3 has got no leg to stand. Accordingly, reject the argument as advanced by the learned advocate for the defendant.
39.
In view of the above discussion, I arrived at the conclusion the plaintiff has got no right, title, interest, and the conclusion plaintiff has got no right, title, interest, or possession to 1/8 share in the disputed and hence the present suit is not barred under section 34 of the SPC. Thus, there is an answer in negative.
Typographical error है. No right to replace.
No, no नहीं होना चाहिए. Typographical error है. 39 हाँ. और इसमें एक जजमेंट भी है. 2014 14 SSC page 502 notes.
2014.
14 SSC page 502. Sir. Okay.
2014. 14.
SSC page
50.
502. Relevant paragraph is 13 and 17. From the perusal of the prayer of the plaintiff lordship, he is not possession of the time.
No. He is seeking confirmation of possession or
No,
recovery of
no.
possession.
The simple prayer is plaintiff that the defendant number 1 to 14 be restrained from catching the keys and to grant the permanent injunction. And he the relief itself.
Show me that there is a dispute of title.
Yes, I am
So
coming
that
out.
is-
Some fact is very much relevant source.
You see, the court is recording while discussing section 34 that the plaintiff has been able to prove his possession over 2/8 share with respect to the property.
If the-
It means that there was a dispute.
Yes, and the relief lordship may kindly see the defendant restrained from catching the fees and grant meaning thereby they are not possession of the land, they should property lordship. The relief itself shows that the plaintiff are not possession of the land, the tank lordship. That should
Let us see
provide.
the case of the respective parties.
Yes. It has been mentioned in lordship para. Para 28 lots. The issue number 4 lots. Sorry, para 11 lots.
नहीं आप किसी यहाँ से मत करिए, आप पैरा 2 and 3 पढ़िए उसके बाद
2 and lots. The case of the plaintiff as asserted in the plaint in brief is that he is the co-owner of the property as mentioned in schedule of the plaint. He has got 2/8 share in the same. It is said that late Mahesh Rao, the father of the plaintiff and defendant number 5 has hold and possessed 5/4 share in the disputed tank and pinned by virtue of sale deed taken from the Janki Bhagat in the year 1942. It is said that Mahesh Bhagat has transferred the aforesaid 5/4 share in the disputed tank and pinned referred above in favor of the plaintiff and defendant number 5 through a registered sale deed dated 14/7/1954. It is said the plaintiff and defendant number 5 were minor at the time of execution of the aforesaid sale deed. It is said that the plaintiff and defendant number 5 came in peaceful possession over the aforesaid 5/4 share in the disputed tank. It is said that on 7/1/1967 the plaintiff and defendant had given 2/8 share out of disputed tank to Suleiman defendant number 1 on Thika settlement for period of 12 years from 7/1/1967. It is said that the period of Thika settlement has expired on 7/1/1979 and after expiry the plaintiff came in possession over 2/8 share in the disputed tank. It is said that plaintiff after expiry of the Thika period of defendant number 1 put JIRA to the extent of his share in disputed tank since he is putting JIRA in the disputed tank every year. It is further case of the plaintiff that defendant number 1, Muhammad Ilyas, is the son of defendant number 1, Muhammad Suleiman. It is said that defendant number 2 is the Thika holder over 5 annas 4 share in the disputed time relating to co-sharer of the village calendar. It is said that defendant number 3 has both the right title interest over any portion of the disputed time and field. It is said that the defendant number 3 is the nephew of the defendant number 1. Hence, all the defendants being in collusion with each other have been trying to misappropriate the proceeds of the disputed time without giving any notice to the plaintiff. It is said that they have been further trying to.
ये defendant number 1 पढ़ाएंगे. Para 5.
Para 5. Defendant number 1 to have contended the suit after filing their separate written statement. Defendant number 1 has filed his separate written statement. Defendant number 2, 4 have filed their joint written statement, and defendant number 3 has filed the separate written statement. The written statement has filed by the defendant number 1 to 4 are identical. Defendant number 1 to 4 in their written statement having inter alia pleaded that suit as framed is legally not maintainable and plaintiff has got no cause of action or right to sue. It is said the suit for grant of permanent inaction against this defendant cannot be maintainable because there is no any consequential relief claimed by the plaintiff in the suit. It is said the suit is also barred by the principle of estoppel, waiver, acquiescence, and res judicata. It is said the suit is also barred under Section 34 of the Specific Relief Act because the plaintiff is out of possession of the suit property. It is said the plaintiff did not seek relief for declaration of his title over 2 anna 8 pi share in the disputed time and in hence the pertinent suit is barred under provision as laid down in the Specific Relief Act. It is further case of the defendant number 1 to 4 that it is true that the Mahesh Bhagat and Ganesh Bhagat have purchased 5 anna 4 pi share in the disputed time and field from the Janki Bhagat through the registered sale deed 24/8/1942 and they came in joint possession over the same. It is said that Mahesh Sahu has sold the aforesaid 5 anna 4 share in favor of defendant number 1 through the registered sale deed dated 26/9/54. It is said the defendant came in possession of the aforesaid 5 anna 4 pi share in the disputed time. It is said that Mahesh Bhagat with his bad motive and malafide intention after being influenced by Etwari, the mother of the plaintiff, and defendant number 5 had cancelled the sale deed 29/6/54 through the registered deed of cancellation and executed a fresh sale deed on 14/7/1950 in favor
There
of
is
the.
a clear-cut dispute on title. Yes, respondent. There is a clear-cut dispute.
No, there was no dispute of title. Fact of this case is, the matter relates to a deed. It is.
Have you seen the judgment that he has cited? That it, I think, let us be on the same platform so far as dispute of title is concerned. If there is a dispute of
I am
title,
also citing two documents. 2008 का 4 SCC. Here, madam, it is said by the original. इसमें से पारा 21 देखा जाएगा 2008 का 4 SCC 594 पारा 21 मतलब the Supreme Court has categorically held mere simply saying that there was no title. In every suit the other defendant will come and say no title. Then the Honorable Court has said that there should be a genuine dispute of title. It is not a mere dispute. Simply saying a dispute is there, so therefore court is ousted from entertaining a petition of permanent injunction. Likewise, in 2019-17 Supreme Court, the same ratio has been reiterated by the Honorable Supreme Court, wherein the Honorable Para 21 को पढ़ ही देता है. So पहले law को ही clear करना. To summarize the position in regard to suits for prohibitory injunction relating to immovable property is as order. Where a cloud is raised over the plaintiff's title and he does not have possession, a suit for declaration and possession with or without consequential injunction is the remedy. Where the plaintiff's title is not in dispute or under a dark cloud, but he is out of possession, he has to sue for possession and consequential injunction. where there is merely an interference with the plaintiff's lawful possession or threat of dispossession, it is sufficient to sue for injunction simpliciter. As a suit for injunction simpliciter is concerned only with possession, normally the issue of title will not be directly and substantially in issue. The prayer for injunction will be decided with reference to the finding on possession. But in cases where de jure possession has to be established on the basis of title to the property, as in the case of vacant sites, the issue of title may directly and substantially arise for consideration as without a finding thereof. It will not be possible to decide the issue of possession. But a finding on title cannot be recorded in a suit for injunction unless there are necessary pleading and appropriate issue regarding title, either specific implied or noticed in as noticed in so. Where the averments regarding title are absent in plaint and where there is no issue relating to title, the court will not investigate or examine or render a finding on a question of title in a suit for injunction. Even where there are necessary pleading and the issue, if the matter involves complicated question of fact and law relating to title, the court will delegate the parties to remedy by way of comprehensive suit for declaration of title instead of deciding the issue in a suit for mere injunction. Where there are necessary pleading regarding title and appropriate issue relating to title on which the parties lead evidence, if the matter involves is simple and straightforward, the court may decide upon the issue regarding title even in a suit for injunction. But such cases are the exception to the normal rule, and the question of title will not be decided in suits for injunction. But person having clear title and possession suing for injunction should not be driven to the costlier and more vexatiously or wrongfully makes a claim of title or tries to encroach upon his property. The court should use its discretion carefully to identify cases where it will inquire into the title and cause where it will refer to the plaintiff to a more comprehensive suit depending upon the facts of the case. So, my lord, in the present case, what is? Issue is with regard to my lord one tank. This tank, my lord, belongs to my lord three brothers, namely Bal Govind Bhagat, Yugal Kishore Bhagat, Janki. All were having my lord 1/3 share in that property. Now, my lord, this Janki Bhagat has gifted his share to his two sons, namely the plaintiff and defendant number 5. Now, my lord, this plaintiff has come for only saying that because all the three co-sharers are there, so they are rearing the fish. Now, if my lord one co-sharer goes and catches the fish, then others will be ousted. So he has moved before the court saying that whenever this catching of fish will done by the parties, all should be there and information should be there, because this petitioner was at that relevant time, my lord, working in HEC. So in any day someone goes and catches the fish, so his share will be denied. Kindly see the relief granted by the court. The honorable court, learned court has simply said that while catching the fish, all the parties should be informed. इतना ही सा रिलीफ दिया है कि भाई सबको खबर करके आप मछली मारिए ताकि 1/3 हिस्सा बढ़ सके. अब इसमें जहां तक टाइटल का इशू है, इसमें टाइटल का इशू है जो कि इनका अपीलेंट है, इसमें हजूर ये भी हुआ था कि फर्स्ट अपील वाज नॉट प्रेफर्ड बाय ऑल द डिफेंडेंट्स. ओनली दिस अपीलेंट हैज प्रेफर्ड फर्स्ट अपील बिफोर द लर्नेड कोर्ट. Subsequently, in second appellate stage, all the persons who have not preferred appeal have moved before this honorable court by filing an IA that they be allowed to contest the appeal. Now, this main contesting defendant, my lord, defendant number 1, was having a lease from one of the co-settlers. His lease has expired, now he is no more. He is having no concern with the property. So far as this appellant is concerned, my lord, I am clarifying it. Mahesh Bhagat, Janki Bhagat was having two sons, Mahesh Bhagat and Ganesh Bhagat. Now, my lord,
Mahesh, the sons of Mahesh Bhagat are plaintiff and defendant number 5. The sons of Ganesh Bhagat are Ravinder and Ravinder Bhagat and Raghunandan Bhagat. They partition the property, the Mahesh Bhagat and Ganesh Bhagat both partition the property, and this tag was given in exclusive share of Mahesh Bhagat. This is the pleading of the plaintiff. Now when this dispute has arisen, the defendant, just to create a title, has purchased by registered sale deed dated 19/3/1976. This is the only case of the present appellant. कि 1976 में इसने रविंदर भगत और रघुनंदन भगत के साथ जो है एक सेल डीड किया.
डिफेंडेंट नंबर 3 किया है.
डिफेंडेंट नंबर 3 हुई तो appellant कमरूल भगत.
डिफेंडेंट नंबर 3 किया है.
कमरूल होता. I am talking about. He is the appellant here. वही appellant है. कमरूल होता जो है वो रविंदर भगत और रघुनंदन भगत से उसने कहा कि हम एक परचेज कर लिए. देयर आफ्टर my lord he files an application before the circle officer on the basis of this sale deed for registration of his land. The same was refused.
There was a dispute on title.
My lord.
See, the court also recorded a finding that the plaintiff has proved his title.
Approved his title.
So
Because वही तो हम
there
बता.
was a dispute. That is why he has proved his
No,
title.
proved his title. If I am seeking an injunction, then I have to prove my title. Actually, I have to show that I am the owner of the property. Then only I can say owner and possession has to be shown. Then only injunction.
You see, there is ownership and possession, and if there is any dispute with regard to that,
That
the
is not-
defendants had disputed the title.
No.
It is not ornamental dispute.
What? Oh, this is ornamental. Why I am saying Manas? I will satisfy Manas. That he says कि I have purchased this particular appellant says कि because to Anna 8 part share also belongs to Ravinandan and Raghunandan, so I have purchased it by a sale deed. Now, my lord, after purchase in 1976, he files an application before circle officer. We have contested the same. Circle officer rejected. Against that, appeal was preferred. The same was also rejected, and thereafter nothing. So the state has not recognized his, the sale, and in the suit, we have brought on record the partition deed in between Mahesh Bhagat and Ganesh Bhagat, wherein it is categorically stated that this particular property was given in the share of Mahesh Bhagat. And my lord, this appellant, after losing in before the revenue authority in getting her name mutated in the Srista of the state, has moved nowhere. And that is the only basis and that is the only point he is saying that title is there. Now, so far as present is concerned, neither this appellant nor the lessee is there. Purchase is of 1976. Had he was having any title over the property or anything, he ought to have filed the suit because he has lost in the revenue courts.
So,
Further, your appellant का
revenue court से पूरी
रेवेन्यू कोर्ट में उसका हुआ नहीं है, उसका कहीं नहीं हुआ.
आपको सूट फाइल कर दिया काफी है.
और हमारे
हर एक कोई जिसका
हाँ,
भी टाइटल से मतलब होगा, हर एक कोई सूट फाइल कर
the trial court as well as the appellate court, my lord, properly consider the fact कि पार्टीशन डीड ले आए. पार्टीशन डीड में आ गया कि भाई महेश भगत का था तो ये दोनों का कोई शेयर ही नहीं था, तो उनका सेल डीड का कोई वैल्यू नहीं रह गया. दिस हैज बीन प्रॉपर्ली कंसीडर्ड. आई विल my lord refer.
See,
अब दूसरा है
just a moment. The sale deed executed by Ravinder Bhagat in favor of defendant number 3.
Ravinder and
Raghunandan in favor of defendant number 3 has been declared to be a manufactured document.
Yes.
Without consideration, and therefore it has become inoperative.
No, हम वो तो ट्रायल कोर्ट बोलना अपलेट कोर्ट का देखा जाएगा जो उसमें ये नया है ना कि चूंकि रेवेन्यू कोर्ट में उसका नहीं चला, वहां पर हम गए रेवेन्यू कोर्ट में हम
Appellate court ने इस finding को reverse कर दिया है.
नहीं
Therefore, when a court is declaring a sale deed a registered sale deed as null and void and manufactured, right? And without consideration, you say that there is no dispute on title.
No. What I said कि because this Ganesh Bhagat
आप हमको खाली इसका आप बताइए, ये जो सेल डीड को null and void डिक्लेयर कर दिया है।
null and void नहीं डिक्लेयर किया जी, बोला
नहीं,
कि
आप देखिए ना, आप पढ़ के सुनाए।
नहीं हम
नहीं पढ़े तो आपको पढ़ के सुनाओ।
नहीं, हम अपने कोर्स से बोल रहे हैं।
ट्रायल कोर्ट नहीं पढ़े, ट्रायल कोर्ट पढ़े ना, फाइंडिंग है ट्रायल कोर्ट का। अगर एपेलेट कोर्ट उसको सेट असाइड नहीं किया है तो फाइंडिंग स्टैंड्स एज इट इज।
दो को लगा हुआ था सप्लीमेंट्री में, इसलिए
नहीं, ये सब कहानी मत सुनाइए। दो को लगा हुआ था तो जजमेंट नहीं पढ़े। हमको कितना टाइम लगा पढ़ने में?
नहीं, हमारा दूसरा कहना है, हमारा कहना है
नहीं, आप हमको सिर्फ इतना बता दीजिए, इन अ प्रोसीडिंग वेयर द सेल डीड इज डिक्लेयर्ड टू बी null and void for want of consideration, you said that there is no dispute on that.
my submission before this
सबमिशन नहीं पर इसका जवाब आप हमको दे दीजिए। Can a court in a suit for injunction declare a sale deed as null and void without any declaration, seeking any declaration to that effect? बताइए।
so far as that finding that part is concerned, मतलब
हम तो खाली अपना जजमेंट देख रहे हैं, हम तो सब्सटेंशियल क्वेश्चन ऑफ लॉ देख रहे हैं। If there is a serious dispute regarding title,
हम वही कह रहे हैं ना, तो सीरियस डिस्प्यूट होगा तब
तो सीरियस है ना, आप किसी सेल डीड को null and void डिक्लेयर कर रहे हैं,
null and void
सीरियस डिस्प्यूट नहीं है।
यहाँ हम
What else is required? ये जो सेल डीड है 1976 का, is it relating to the suit property or not?
मेरा कहना है जब गणेश
कहना नहीं, आप हमको ये बताइए 1976 का सेल डीड, is it relating to the suit property or it is not relating to?
वो तो suit property से
उसको
related
null and void डिक्लेयर करें, आप बोलते कोई डिस्प्यूट नहीं।
इसको हम क्लैरिफाई कर देंगे।
क्या क्लैरिफाई करेंगे इसमें?
हमारा कहना है कि अगर वो फाइंडिंग दिया कोर्ट ने तो दैट फाइंडिंग सो फार एज दैट फाइंडिंग इज कंसर्न कोर्ट को सिंपली उसको इग्नोर कर देना था। अब कोर्ट ने एक फाइंडिंग दे दी,
कैसे इग्नोर करना था?
इसलिए हजूर की रेवेन्यू कोर्ट में
We do not know. We are only confined with the substantial question of law framed, and there is a clear-cut finding of the trial court that it was null and void. Now you tell me the appellate court has said that this finding is incorrect.
Appellate court has said, my lords, that because there was partition writ, which goes to prove that this property was given to my.
There is a serious dispute of that.
अच्छा, इसको हम हजूर नेक्स्ट मंडे को इसको हम पूरा क्लैरिफाई करते हैं।
Monday
उतने पॉइंट है,
परसों
छुट्टी है, अभी सारा छुट्टी है।
कल भी छुट्टी है।
कल छुट्टी है,
कल भी छुट्टी है,
परसों
सैटरडे है,
परसों शनिवार,
शनिवार सैटरडे है, उसका संडे है, उसका सोमवार को बोल रहा हूँ।
टाइम लेने के लिए कितना बाउंड्री है?
खाली चूंकि 2 केस लगा हुआ था इसलिए उतना
तीसरा डेट हो गया है इसका।
नहीं, पहला डेट
पिछला बार भी तो कुछ तो बहस
तो सब्स्टिट्यूशन था।
सब्स्टिट्यूशन में एक गलती हो गई है।
अब गलती भी हो गई है।
हाँ, गलती हो गई है,
खाली वो जो रिस्पोंडेंट नंबर 12 लिखा गया था उसको 5
हो गया,
वो करेक्शन कर दिया गया,
क्योंकि आईए पिटीशन में रिस्पोंडेंट
अरे,
12
हमें knowledge में
लिखा
डाल दिया।
हाँ, इसीलिए मिस नोट दिया। आईए नहीं होगा।
रिस्पोंडेंट नंबर 5 होना चाहिए।
5 होने चाहिए।
नाम लिखे हैं रिस्पोंडेंट का?
हाँ, नाम
जिसका
लिखा है।
डेथ हुआ है?
हाँ, नाम राम नारायण करके लिखा हुआ।
Second appeal number 1 of 1999 written by Tata. The learned counsel for the parties have jointly submitted that in order dated 28th of October 2025 and an error has been kept up
11
in as much as respondent number 5 has expired and not respondent number 12. They have referred to the memo of appeal and have submitted that Ram Narayan Bhagat is respondent number 5 in the case. Considering the reported submissions, at this the learned counsel for the applicant has also submitted that he may be permitted to make necessary correction in the interlocutory application. सब में IA number है ना?
जी आई
In all the interlocutory applications, being IA number 10751 of 2025, being IA number 1147 of 2025, and IA number 1147 of 2025. दो ही आई है ना?
दो आई
हाँ. And instead of respondent number 12, he may be permitted to insert respondent number 12, respondent number 5.
फाइव
Counsel for the respondent. आप भी इसमें 12 ही लिख दिए थे क्या?
हाँ,
ये 12 लिखे थे इसीलिए हम 12 लिख दिए
उसमें देख लिए।
मेरे पास मेमो
नेट पे था वही लिखा हुआ था।
इनका फिर गलती हो गया
The learned counsel for the respondent has also submitted that in IA number 10751 of 25, instead of respondent number 5, respondent number 12 has been mentioned, but the name of the deceased respondent, that is Ram Narayan Bhagat, who is respondent number 5 in this case, has been rightly mentioned. He also seeks permission to make necessary correction in IA number 10751 of 2025. After hearing the learned counsel for the parties, counsel for the respondent is permitted to make necessary correction in IA number 10751 of 2025 by deleting respondent number 12 and inserting respondent number 5 at various places in the interlocutory application. Consequently, the order dated at various in reading during the course of the day. Similarly, IA number 1147 of 2025, the counsel for the appellant is directed to delete respondent number 12 at various places and insert respondent number 5 in the interlocutory application. As a result of the aforesaid amendments in the two interlocutory applications, the order dated 28th of August 2025 is hereby modified, and the respondent number 12, as mentioned in paragraph 1, paragraph 3, and paragraph 5, be deleted, and in place of that, respondent number 5 be inserted. That's it.
Yes.
Office to carry out necessary amendments in order dated 28th of August 2020. Post this case for further hearing on Monday at 10:30. आ जाइए 10:30 बजे. लड़ने वाला केस लड़िए, फालतू वाला केस मत लड़िए।
इसमें जो खाली उसका देखा जाएगा इंजेक्शन जो पास हुआ है इतने का है कि जब मछली मारिएगा खबर कीजिएगा। आज ना अपलेंट है ना ये लेसिफ।
दोनों जने मिलकर बोल दीजिए इन्फ्रक्शन हो गया तो मैसेज डिस्कस कर लेंगे।
तो ऐसे होना चाहिए था, इनको बोलना चाहिए था।